before we start, let's get some housekeeping matters from Kim.
Okay. Welcome committee members, liaisons, and members of the public to the Council on Access and Fairness meeting. Thank you for joining us. We will begin shortly. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to make a comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and the message will be sent to the host. Alternatively, you can also use the raise hand feature. In an effort of transparency for those joining this public meeting, whether by Zoom or by phone, we request that you refrain from having side conversations in the chat about the content of the meeting. Again, the chat feature is utilized to simply as a tool for you to virtually indicate that you have, excuse me, that you would like to speak in order to help the chair facilitate the discussion. Going forward, COAF meetings will be recorded and posted to the State Bar's website. A friendly reminder, this is a video conference meeting, and please be aware of your surroundings behind you. For those joining on Zoom on computer, when on mute, holding down the space bar will temporarily unmute. If you use your phone to dial into the meeting, please be sure your computer microphone is on mute to avoid audio feedback. And while joining audio via computer is highly recommended, if an individual loses audio, they can call in separately using the Zoom conference number. Thank you.
Thank you. And again, good morning, everyone. It's good to see everybody in their little boxes on Zoom. Let's go ahead and call roll.
Okay. Judge Esther Kim.
Present.
Ryan Harrison.
Present.
Heather Anderson. Novella Coleman.
Here.
Sarah Good.
Here.
Michael Rhodes.
Here.
Shalak Richards. Judge Kristen Rossi.
Here.
Stephanie Santoro.
Stephanie, you're on mute. But we still can't hear you.
Says I'm.
But we see her.
Okay. Sal Torres. Okay, so we do have a quorum, Judge Esther, but I'd also like to call roll for our liaisons. Okay, Pat Lee.
Here.
Kenneth Wang. Judge Yu. Melanie Shelby.
Present.
Jose Cisneros.
Here.
Great. And I also wanted to acknowledge that we have some staff with us. Crystal Bundang.
Here.
And Gagan Kaur.
Here.
And Lisa Chavez.
Here.
Okay.
And I wanted to acknowledge our two Board of Trustee diversity liaisons, Jose Cisneros, and I believe Miss Melanie Shelby, you're joining us for your very first COAF meeting, isn't that right?
That is correct. Thank you.
Well, welcome. And I'd like to give both of you an opportunity, if you wish, to say a few words to our COAF members.
Thank you, Judge Kim. Hi, everyone. I'm Jose Cisneros. I'm one of the board members. I'm located in San Francisco. I've been on the Board of Trustees for a couple of years now, and I've been happy to serve as liaison to COAF for the entirety of that time. I am very proud of the work that COAF is doing, and I'm here to share with you the dedication that the board has for this work and for our partnership with COAF. We've done a lot of great work in the past, but we still, in my view, have far more to do going forward to continue to support the legal industry here in California and to make things better for everybody who wants to serve in that industry and who needs to be served by that industry. Your work is invaluable in that effort. And I'm also proud to be and honored to be joined by our still, I think, what can I say, Melanie, new Board of Trustee member, Melanie Shelby, who I'm sure will do a fantastic job also. Melanie, I'll hand it over to you.
Good morning, and thank you, Judge Kim, and to everyone on COAF. My name is Melanie Shelby, and it is such a pleasure to be with you this morning. Unfortunately, I missed the meeting in February and will remedy that. And I'm going to apologize in advance. I have a conflict, and so I'm going to depart from 11 to 1, but I will return. As background, I serve as managing director for a minority and woman-owned public affairs firm located in Oakland, Gray, Greer, Shelby, and Vaughan. And we'd like to say that we fix, build, and connect. And so I believe the governor's office identified me because of my 25+ years of diversity and inclusion experience. I am elated to be here. And one of the things that I shared in my interview last week prior to that, I served as an energy lobbyist for 10 years in Washington, D.C., Sacramento, and doing regulatory work, just as a grounding. But one of the things I shared last on Monday, I believe, when I had the opportunity to engage with senior staff as it related to my hearing for what I hope to be confirmation, which will be coming up soon, is that for me, diversity and inclusion is definitely one of my primary goals. And I would love to see diversity and inclusion embedded throughout the state bar, the same way that fiscal impact is embedded. I know back in 2017, during the strategic planning process, diversity and inclusion access were added to the mission, but I hope that the work that I've done across multiple industries will be of service. I'm here to learn from you and really look forward to getting to know each and every one of you. So thank you for having me.
Thank you so much. And I know, Jose, we worked with you so much and so well last year. Thank you for just your generosity of time and for your commitment to COAF. And Melanie, we're so excited to have you because we're only greater when we are bigger in number. So thank you. And do we have anyone in our public that would like to make a comment? Or do we have anyone joining us at all?
There's 4 people, but no one's indicating that they want to speak.
Thank you. And so again, I want to welcome everyone. Can you believe that we're halfway through the year and we're already in the process of picking a new member for COAF. And while I asked Elizabeth if it may be hopeful that we're going to meet in person in September, that may not be the case. But it's great to just see you in the Zoom meetings and at least to see each other's faces. And so lots to go forward with on today. So let's start with our consent. So are there any comments to the February 5th meeting summary? Hearing no comment, may I get a vote, a motion and a second to approve the February 5th meeting minutes?
I move to approve the February 5th meeting minutes.
Thank you, Ryan. Do I hear a second?
I'll second.
Thank you. That was Michael. And Elizabeth, roll call vote, please.
Judge Esther,
Aye.
Ryan,
Aye.
Heather, Novella,
Aye.
Sarah,
Aye.
Michael,
Aye.
Shalak, Kristen,
Aye.
Stephanie, okay. Sal? Okay, so the motion carries.
Thank you. So let's go on to our state bar reports. An update on our Office of Access and Inclusion activities and staffing. How are we doing, Elizabeth?
So I just wanted to give a really brief update that on the staffing side, we do have positions open for 2 senior program analyst positions. And so we've been recruiting for those 2 positions. And we will soon be recruiting for a senior financial analyst position. So we are busy on that front. Additionally, I did want to bring to your attention that the Legal Services Trust Fund Commission, who COAF has and continues to work with, met to finalize the 2021-2022 PLL grants, and PLL is the provisionally licensed lawyers. And so these grantees would employ full-time provisionally licensed lawyers across the state in a variety of civil legal issues facing indigent Californians. And so as many of you know, the provisionally licensed lawyer program was implemented, was launched in November, and in response to the COVID-19 pandemic, to allow for temporary supervised practice for attorneys, and was expanded in January to include individuals who scored 1390 or higher on any bar exam administered between July 2015 and February 2020. So I thought that would be of interest to COAF. That is my state bar kind of OAI update.
Thank you. Any questions? On a separate note, Elizabeth, I did have a question with regards to OANI. I know this year it might be a little difficult with the COVID-19 pandemic, but next year, are there any law student or college student opportunities for internships at the Office of Access and Inclusion?
That's a good question. I think the state bar broadly, we do have internship opportunities. I would need to check with our recruitment and retention office to get a little bit more information about what those internship opportunities are. But that is a good question.
And are those internship opportunities available online, just so that we can share it with our networks?
I'm not sure, so I can check with our that office and get back to you.
Okay, great, thank you. Any other questions for Elizabeth? Then moving on to the update on initiatives to improve the attorney discipline system. And I believe we have Lisa giving us a report.
Hi, good morning, everyone. Nice to be here again. I'm going to go ahead and share my screen so we can get started. So I believe that it was in fall that Dag McLeod and I spoke to this group about, gave an overview of the State Bar's projects that we have been undertaken to address disparities in the discipline system. I think in that meeting, we gave really a lot of details about the study that informed the recommendations that led to projects. So what I'm going to do today is just take us straight to those recommendations that Professor Chris Robertson generated as a result of the research conducted by Professor Farkas, where he found that there are indeed disparities by race, ethnicity, and outcomes in the discipline system. Professor Robertson took that research and gave the State Bar a set of around 13 recommendations on reforms to engage in. And what I'm going to do is I'm going to systematically go through each recommendation. I'll start first with the ones that have already been addressed and or completed, and then I'll go to the rest and talk about the plan for this year to address those. So that's the plan for today. First, I'm going to do that, and then I'm going to finish with giving you an update on the ad hoc commission on the discipline system. That is also, we also at the State Bar consider that a project or an initiative to address disparities in the discipline system. So let's get started. Professor Robertson, again, he looked at the results that Professor Farkas generated and recommended that the State Bar engage in reforms regarding three big areas of the discipline system. First has to do with reportable action bank matters, and this is a particular type of complaint or allegation issue that attorneys encounter that can lead to discipline. Another has to do with doing research on complaints closed without discipline. And then finally, he had a set of recommendations regarding attorney representation. So let's start with reportable action matters. These are the three reforms that he recommended. The two reforms. The first was that he recommended raising the de minimis threshold that triggered an investigation, and staff researched the issue and declined to act on it. And we did a whole presentation to this to our Board of Trustees last year. The second potential reform was to allow attorneys to deposit funds into client trust accounts kind of as a cushion, and staff reviewed the issue and also declined to pursue this option. And again, we outlined all our reasons to our Board of Trustees. But in lieu of those reforms, our Office of Chief Trial Counsel engaged in proactive preventative approach to this by instead taking a really hard look at the letters that are generated in response to reportable action bank matters coming into the State Bar. And they've improved those letters by expanding the resources that they make available to attorneys, really changing the language to really impress that this is an issue that they need to look into, etc. And so the next step for this work for the State Bar is to research the impact of these letters. So with regards to complaints closed without discipline, Professor Robertson recommended that one option for the State Bar is to expunge these complaints after 5 years. So that is, attorney receives complaints after the State Bar does not act upon them, just expunge them from the record after 5 years. Staff reviewed this and declined to do this in favor of the other potential reform that he recommended was, you can also archive them from staff view. So that is, so picture staff, a complaint comes in, they have access to an attorney's entire record. Well, complaints that were closed without discipline, once they're 5 years old, they're archived from view and staff can no longer see them. And so we actually engaged in that and we completed that project and we shielded around 400,000 complaints from view. And then finally, with regards to attorney representation, Professor Robertson recommended these following reforms. First, he said that we should start tracking and reporting the proportion of discipline cases that are lacking representation. We completed this and we're going to start reporting this to the Board of Trustees starting in July of this year. And he also recommended that the State Bar really reach out and inform attorneys that are facing discipline about the increased statistical likelihood of discipline if they do not have representation as they engage in being investigated and go to State Bar court. And staff did complete this project. The next slide slide shows on the right, this is the actual letter that we make available to attorneys who are under investigation. Let me put a little caveat and say at this point, we're finishing up a randomized trial of this letter. So only about half of attorneys are receiving this letter because we want to see if it's having an impact. So we're comparing it to attorneys who receive this letter once they're under representation. As you can see, very bold language, your California bar license is at risk, take action for these reasons. And we want to compare to see if this is if attorneys who are receiving this letter are more likely to engage in counsel than the attorneys who are not receiving that letter. We're going to be analyzing those results this summer. And the goal is moving forward, everyone is going to receive this letter, but perhaps we'll update this language based on what we learn. So I just finished describing all the projects that have been completed, and now I'm going to turn to the set of reforms that the State Bar didn't act upon last year, but we're working on this year. So back to reportable action bank matters. So Professor Robertson recommended that the State Bar revise the guidance that we currently have in place that encourage attorneys to use resources to prevent the trust accounting errors. And the Office of Professional Competence took this on in Q1 of this year, and they recently updated all their resources, including the Handbook on Client Trust Accounting for California lawyers. Professor Robertson also recommended that the State Bar explore kind of developing like a turnkey banking and checking bookkeeping system that could be a potential solution for attorneys so they can deal more effectively with their client trust funds. Professor Robertson is exploring this option with relevant stakeholders, including our partners, Office of Access and Inclusion. But one thing that they're really kind of coming to terms with, that this reform may be a little bit more applicable to an attorney membership organization rather than an attorney licensure agency like the State Bar. So this is still ongoing, but I just wanted to share with you that this has come up in the conversations. With regards to complaint closed without discipline, reform has to do with trying to develop a proactive non-disciplinary support system for attorneys who are high risk of future complaints. And what this means is that we should do research to understand what categories of complaints that are really at high risk for discipline, what types of attorneys practicing certain types of law are at higher risk for discipline, so we can develop resources being a little bit more proactive to prevent discipline misconduct before it happens. And so our staff has initiated a research plan to understand allegation patterns, case closure reasons, etc. And these results, which we're working on all this year, we're hoping will inform this proactive preventative approach. And then finally, with regards to attorney representation, Professor Robertson recommended that we develop a roster of attorneys who will agree to provide pro bono 1-hour consultations, also develop like a sliding scale fee representation by the private defense bar. And so Professor Robertson, again, working with us, he's working on this with RAD leadership, relevant stakeholders, including the ADDC. One thing that has come up in this work is like how, if ultimately the sliding scale issue, you have to figure out how to means test people, like how do you determine how much people earn, how do you measure earnings, right? This is like turning out to be quite a just a real element that needs to be really fleshed out if we really want to make this happen. So, so that's ongoing. And then also State Bar Court is actually interested in developing attorneys' help materials. And so Professor Robertson is familiar with one state, I forget which it is, that actually has done this. And so we're going to initiate that this year as well. Okay, so that's all one last reform. Professor Robertson recommended that the State Bar create a discipline equity office to implement reforms, minimize disparities, ensure that discipline decisions are fair, and support unrepresented attorneys. So, at this time, we don't have really the resources to develop this such an office, but we suspect that the Ad Hoc Commission on the Discipline System will look at this recommendation and probably recommend that we do what we need to do to develop such an office. So this is something like at this time, we have resource constraints, but we know we're going to be continuously open to it. Okay, so that's an update on all the projects as a result of the disparities research and recommendations. Did anyone have any questions about anything I just showed?
Hey, Lisa, it's Heather. Oh, I'm sorry, Brian, your hand was up first. Go ahead.
Thank you. So yes, I'm concerned about the considerations leading to the decision to not increase the overdraft threshold for the trust fund accounts. I'd like to explore those. And here's my main concern. Sometimes small shops, solo practitioners might write a check from the wrong checkbook, right? Actually, I hear about this a lot. My wife is an assistant vice president at a business bank. And there's a small mistake corrected almost immediately, but there's a report that has to go to the bar. The bar sends, really scary papers to these attorneys, and they have a very significant stress response to that, often taken out against my wife. But the level of stress is very high. And we all know that the legal profession is a very stressful profession to be in. When it comes to these small little incidents that maybe don't include a high overdraft amount, maybe $100, maybe 200. Why is that stress level justified? Why can't we just increase the threshold to a meaningful level that is more indicative of fraud?
I'm sorry, I don't really have an answer for that. But I'm sorry. I don't have an answer for that other than like we researched the issue and we concluded that the research that doing so would really, I believe our research showed that doing so would potentially have us miss true misconduct because they tend to pile up. The people who are disciplined over this issue, it's like these are just like small issues that lead to bigger issues. So I think that I believe that was the reason why we declined to do that. But I hear what you're saying about the stress that even the letter that comes, even though the intention is good, right, to warn, it's still stressful. So I can see your point about that.
Is there a way we can revisit this, or is the ball, completely off our court? I would like to try to turn that around.
Mm-hmm. I don't know. I'm sorry.
So Lisa, I can take that. Yeah. So Ryan, I think this is something that would be totally appropriate for the ad hoc commission to be looking at. They've got 2 tracks. They're looking, right, I think Lisa mentioned sort of fairness and effectiveness. And so this would be totally appropriate for them to sort of having the same presentation from Lisa say, you know what, we may want to recommend further study on this, further consideration by the board to change that. You know, Lisa was referring in part to the analysis that we were doing on, you know, if we increase the de minimis amount before we send a warning letter of sorts, and the research there did not, because the thinking was, well, let's up it from, you know, from a minimum threshold a little bit higher, as you were suggesting, and the research was in fact suggesting that does not, that sort of the higher levels do indicate either, you know, that represents a higher likelihood of misconduct or higher likelihood of misconduct in the future. And so that's why the board looked at it and decided that they weren't going to increase that de minimis threshold. I personally can't recall the exact discussion on the issue of allowing sort of a bigger cushion in the excuse me, in the trust account for some overages, or if there were not you know, sort of writing a check sort of before the funds cleared. And so it's certainly something that the ad hoc commission, I would expect, would be sort of reviewing all of these recommendations that were not acted upon to determine if they think that the board should reconsider them.
Thank you.
So I think Heather had a comment, and then Kristen.
Yeah, I had a comment, but before I say that one, just on Ryan's point, I have a slightly different viewpoint in that I think our profession requires precision and a lot of regulations around how you formulate a response or pleadings or something that have rules and regulations around them too. And so I don't know how much I lean into, like, sometimes, you know, people are just making mistakes using the wrong checkbook. I would be then very concerned about, are they also making mistakes in my filings, right? So I wouldn't want to start a slippery slope there of it's okay in this space, because then it can become okay in other spaces too. So I would just think that's something we want to take into consideration, but that wasn't why I raised my hand. I wanted to ask about, or just make a comment about the research patterns and practices that research on patterns and practices that the committee is going to do. I think it would be helpful to share that information with law schools so that they could start to consider some programming, maybe a clinic or something at the law school level to start to teach students about the various practices that may lean into these issues. We've talked before about how professionals, not just attorneys, but doctors and dentists, while you learn the substantive parts of your practice, there aren't courses around how you run a business. And so maybe this research could help feed to the law schools a curriculum around, if you choose to go into these practices, particularly if you choose to do solo practice or small firms, these are the types of things you need to be aware of, because it could create real disciplinary action for you later on down the line. So I would just want you all to consider sharing it with them as you come across this research.
If I can add also on that same front, Heather, so the attorneys in the group may be aware, and you'll be getting some communications about it this summer, but the State Bar updated its rule regarding what information that we're requiring attorneys to provide to us. And so one of those things that we are now requiring attorneys to provide is information on practice sector and firm size and firm type. And one of the key reasons for that is because we know that people do switch from a government practice to a solo practice, or even a small practice to a solo practice, where they have not had responsibility for a client trust account. And, you know, and so there are these issues where maybe it is not sort of being a bad actor, but not having the information at your fingertips to know the rules. Obviously, right, we all, as lawyers, we expect everybody to know what the requirements are. But if you are dealing with client trust accounts for the first time, you might not have all of the information on what all of the obligations that you have are. And so by getting this information and requiring lawyers to update if they change firm size, firm type, then we can send out a notice saying, hey, I see that you just transitioned to, a solo practice, congratulations. Here are some resources that we want to draw your attention to. Right, so resources, and that's literally the initial purpose behind us requesting this information, was to be able to provide that education to people in a non-threatening way, non-anxiety producing way. Like, hey, this is a great thing. You've just, opened your own practice. Let me share some resources with you that you might find beneficial. We're also doing a voluntary online self-assessment tool. And we're starting with a client trust account module. So people can sort of use this tool to determine what they know and what they don't know. And that will be followed by an online, the development of an online client trust accounting MCLE, basically, to give people some of the skills. So we're looking at a preventative education approach, providing resources approach as well, because we know that's something that's critically important for individuals. Nobody wants to commit misconduct because of inadvertence. And so to the extent that we can provide them the knowledge that they need in order to meet their obligations as lawyers and meet their obligations to their clients, then that's something that we're trying to do and do in a much better way.
Donna, I seem to recall many years ago, we had a pamphlet on how to open a solo practice. Do we still have that at the State Bar?
Oh, Donna, you're muted.
I thought I could go at least an hour before somebody would say you're muted. I'd have to confirm. That should be easy enough for me to find out. I'm sure I could have an answer back to you shortly, but I don't recall the answer to that question.
And Elizabeth, we had a few more hands.
Yes, Kristen.
Thank you, Elizabeth. So Lisa, I had a couple of questions. With regard to the client trust accounts, Ryan and I were at a meeting back in, I think it was early April, where we talked about this. And I think your slide mentioned that this might be more of an attorney membership issue as opposed to the discipline. Thank you. Thank you for being able to just do that. Amazing. Thank you. And I wasn't sure what that meant, because my memory of the meeting, we spent actually some time talking about trying to make about how not user-friendly these IOLTA accounts are, and how we had hoped to make them more so and get them integrated with QuickBooks and things like that. And so I wasn't sure what that second part there meant. Could you explain that a little bit? Thanks.
Sure. So the recommendation is to develop a turnkey banking, accounting solution for client trust funds. And this has just come up in repeated conversations that Professor Robertson has had, that may be something that like an attorney membership organization should offer. It's kind of like when you belong to a credit union, and that's part of part of your employer type of thing. Rather than, the State Bar, we're a licensure agency, and yes, we're engaging in preventative approaches in lots of ways, but this is like a service, and then it just may be, so it's just something that has come up.
Okay. Yeah. I mean, for what it's worth, since we are requiring folks to have these, I think, and I said this at the meeting before, we should be making it a lot easier, as Ryan indicated, to do. And I want to be cognizant, of course, that every time somebody overdrafts in one of these, somebody is collecting revenue on that, and it's not the attorneys who are being disciplined. So, and the other question I had is, my memory could be wrong on this, but I thought we had talked about also some sort of client trust account school where sort of in a traffic school kind of way, where you get an infraction or you get a discipline and you can go to this program and then maybe make that go away. Is that something we're still thinking about? Or
We have client and trust accounting school. it's not connected to, at this time, it's not connected to discipline at all. Donna, I mean, I don't know if we've ever discussed about linking the two. And
well, it is connected to discipline in that it is a condition. It may be a condition of probation for an individual who is found culpable of some trust accounting related violations, that they attend the State Bar's client trust account school. It could also be you can also voluntarily participate, and so it may be that, you know, if you receive a resource letter from the State Bar, right, you've been notified that you went over the amount, but it's you know, to a low level, you know, that you had insufficient funds in your client trust account. One of the resources that we would point you to is Client Trust Accounting School, which you can participate in. But it's not tied to discipline in the sense that it's not, if you complete this, then the level of discipline will be reduced. It is you have been found culpable of certain behavior, and part of what you need to do to ensure that we're protecting the public and you don't engage in that behavior again is to attend trust accounting school.
Okay. And is there any reason, Donna, why we couldn't at some point, maybe the ad hoc group that's looking at this can maybe consider it more like a traffic school model where I maybe admit that I went over 65, or but if I go, then, you know, maybe this complaint gets archived, or is that going to go with the same issue we had with the amounts that get reportable?
Yeah, I think it's certainly, you know, appropriate for a discussion. What we want to make sure that we're doing is protecting the public, and right, so we don't want to sort of not discipline conduct. Sure. That where the public has been harmed, and more importantly, the public could be harmed in the future if the behavior isn't changed. But it's certainly something that, you know, can be discussed. You know, one of the things you said is if they cooperate and say, I'll go to client trust accounting schools. If you, during the discipline process, cooperation and, you know, coming to an agreement before having to go to a trial is evidence in mitigation. And so the discipline that would be, that, you know, that you could be subject to is generally reduced due to that kind of cooperation. As a sort of, but as it's not a go-to client trust account school, and then the level of discipline will be subsequently reduced. It's part of, you know, you've cooperated in this process, resolved it early, admitted to the underlying issues, saved, you know, resources, and so as a result, that's mitigation and the level of discipline.
Okay. Thanks.
I think I saw Ryan's hand up.
Yes. So I want to kind of further explain what I was explaining before, and then come up with I guess a proposed solution that could rectify this problem, right? So I am on the board of the California Association of Black Lawyers. I'm the treasurer, right? We have a Northern California account and a Southern California account. The checkbooks look virtually identical, except for the very small account number at the bottom of the check. It's so easy for me to write a check from the wrong account. Right. One of the things that would have been helpful is something on a check that indicated Northern California account, Southern California account. I also have an IOTA account that I don't use, right? But it's there. The check for that account is virtually identical to the checks from my personal checking account, right? Very easy to write a check from the wrong account. What if we created a rule for the banks to where they would have to put on their IOTA account checks, IOTA account, big bold letters. There's no way to confuse it. That way, if an attorney did write a check from the wrong account, the level of culpability for that attorney is higher for either their inadvertence or their outright misconduct. That would actually help the bar in protecting the public, as opposed to punishing attorneys unnecessarily for small mistakes.
And is this something that, Donna, would be appropriate for the ad hoc committee to look into further?
Yeah, it absolutely would be. And I personally don't recall looking at checks recently, but there is a requirement, just so everyone knows, that your IOLTA account, your trust fund, your client trust fund has to bear the name, it's client trust fund, trust account. There are various words that need to be in the name of it. I don't know if that appears on the check or not. Brian shaking his head, no, it absolutely does not. And so, so these are all obviously things that we can think about. And there's also, we should be looking at our guides that we provide for client trust accounting, and to say things like, right, we all have a fair amount of flexibility over what our checks look like, right? Colors and, whatnot. And, part of the guidance that we should be giving to people is make sure your client trust account checks look different than other checks that you have. Whatever tools to assist people, because we don't want anybody to be violating the rules due to inadvertence. Right. So anything that can be done to assist that is certainly right. It protects the public, and it helps the attorney as well to not get sort of rolled into the discipline system for inadvertence.
Yeah, well, I mean, we do know, and I didn't mention this earlier because I'm tying this to the issue of diversity and inclusion. Now, we do know that this issue affects minority attorneys significantly more than white attorneys, right? And so this is an issue of diversity. And so I know we can easily put the onus on the attorney. Oh, you should have the bank put that on your checkbook. Why wouldn't you do that, right? But I mean, I think this might be an easy fix to direct the banks to do that and leave the attorney who's busy doing other stuff no choice but to see a check with like IOLTA on it, and they won't have the excuse. Let's say they are engaging in nefarious behavior. They won't be able to have that excuse. Oh, it was an accident. No, it's on the check. It has to be on the check. So that's it.
And it appears that we have some sort of relationship with the bank, since we talked about some of the RA bank matters and some of the issues that we were able to resolve. So maybe this is something that the ad hoc committee can look into further, since it doesn't appear to be something that is not something that we can kind of not foresee in the future. So again, with that relationship, maybe this is something that would be a great recommendation by Ryan and Kristen. Any other questions for Lisa on this issue?
Yeah, Trustee Shelby has a comment or question.
Okay.
Yes, thank you. And this is probably Judge Kim directed more to Donna. I think she might be able to respond to this. The conversation had me thinking as it related to the Ad Hoc Commission on Discipline. I know that they had their first meeting in April, and I believe they'll be meeting again before this month is over. And Donna, it really extends more to coordination and intersection. I know that their first conversation was one of grounding, and they've got an 18-month charge in front of them. But in that conversation, was there any discussion at all as it related to kind of coordination and intersection with COAF, and how will that look moving forward?
So COAF has representatives on the commission intentionally for that very reason. We specifically sought out COAF representation.
Okay.
And so, am I correct, Sarah? Is that you?
That's right.
Yes, and I'm on the Fairness Subcommittee, which I think more properly meshes with, the COAF charge.
Yes.
And we actually have another meeting on Monday, so.
Thank you.
And so Sarah, maybe you can either get the notes or talk to Ryan or Judge Kristen and see to make sure that all the concerns that COAF has raised here today gets addressed at the next meeting.
Yeah, I think that's why this discussion is so valuable, because Sarah is a COAF representative on the group and can certainly bring all of these discussions to that meeting on fairness and to the full commission meeting as well. So Sarah, thank you for participating in that. I think that really adds a significant value.
And Donna, is it also an open meeting in case Ryan and Judge Kristen wants to attend?
Yes, yes, they are absolutely open meetings.
And I can send the meeting information to COAF following this meeting.
Thank you. Any other questions with regards to this issue? And I can only see about 5 boxes, so do you see any, Elizabeth?
No other hands at this time.
Okay, then let's move on. We're going to take an item out of order. We're going to talk about law school retention, and that's also Lisa Chavez.
Hi, sorry, I had more, I just wanted, also part of my presentation on updates to address disparities was to talk about the ad hoc commission. So 5 more minutes, okay? Okay, so let me just go to the end, here we go. Okay, so the ad hoc commission, again, I believe we touched upon the ad hoc commission briefly at the last time that I spoke here at COVAC. Sorry, my parents' dog is barking. Okay, I'm here visiting my parents and the dog barks constantly. Okay, ad hoc commission on the discipline system. Their charge was to take a comprehensive look at the attorney discipline system. And the reason why we formed this is because OCTC has engaged in lots of reforms over the last 5 to 7 years. These are the reforms right here. We also, as I presented, State Bar is engaging several reforms to reduce disparities in the discipline system. And so we formed an ad hoc commission that's charged with 3 big buckets of work. First is to take inventory of all the discipline system reforms that we've undertaken. Second is to evaluate the impact, ask, have these policies had their intended impact? What's the impact on public protection? And then also to review existing studies and commission new studies. And then finally, just recommend additional or revised reforms. So the Board of Trustees appointed members to this group. We have 23 members. 43% are people of color, 17% are men of color, 26% are women of color, and LGBTQIA folks are 17% of our 23-member commission. We have formed 2 subcommittees. One is effectiveness and one is for fairness. And so that is that if you look at the entire inventory of reforms that this commission is going to review, they can be divided between reforms that address effectiveness of the system and the other reforms that address a fairness and other, how to address or increase fairness of the system. These are our stakeholder members. As you can see, we have one person from COAF who's member, who's part of the commission, and these are the other stakeholder categories. Oh, sorry, let me just say that the names of the full roster you can find online on the State Bar website. And let me just share their timeline. As we mentioned, we had our kickoff meeting in April of this year. The subcommittees are all going to have 3 meetings this summer. And the purpose of those subcommittee meetings is, again, just to go really deep into all of the material and they're going to come back together in August as a full commission to discuss their kind of initial reactions, initial set of recommendations, what they're thinking. In September, the commission will give an update to the Board of Trustees. October, the subcommittees will meet once more time to start really kind of honing in on their recommendations. Have another full commission meeting in November, more updates to the Board of Trustees, and then it's full speed ahead next spring to finalize their report, which will be due in June. Okay, does anyone have any questions about the ad hoc commission on the discipline system or the work plan? And thank you, Sarah, for your participation. Yeah. Okay, well, thank you very much.
Thank you, Lisa, for that report. And let's move on to law school retention.
That's Lisa, as well as Crystal from our office. And we also have Natalie Leonard, who's from our Office of Admissions. This is a very collaborative study that we're doing. And Lisette Garcia, also from the Office of Research and Institutional Accountability, is here too.
Thank you.
So,
yeah, good morning. I actually forgot to check in with Lisa to see who was sharing screens, but I can go ahead and do so. Hang on one moment.
Sorry, I'm back. I just had to go ask my mom to like control her dog. Good morning, everyone. As you can see from my background, I am in Southern California, the San Gabriel Valley in particular, my hometown of Monterey Park visiting my parents. So let me get started. Let me find, okay. Okay, sorry. Sorry, whoops. Okay, let me get to the beginning here. Good morning. The purpose of this presentation is to give you an update on the law school retention study. This is a study that my office, the Office of Research and Institutional Accountability, is conducting in partnership with the Office of Access and Inclusion. And so this study on law school retention has three components. First, we've conducted a survey of California law schools on issues of recruitment and retention of diverse students. This study will also do an analysis of law school enrollment. And again, this is focused on California law schools. And then finally, we will conduct an analysis of attrition. So let's talk about the survey. We administered this survey to all 53 law schools in California. It was an online survey that was made available to them in October through February of this year. As you can see, we have three different types of law schools in California. Those that are accredited by the American Bar Association, those that are accredited by the community bar examiners, and those that are unaccredited, but they're registered with the state bar. There's 53 total, and you can see the response rates here on the right. Whoops, sorry. We have this really great response rate, largely due to our staff in Office of Access and Inclusion, who reached out to the folks at these different law schools, encouraging them, cajoling them, maybe bribing them, I don't know, but this is a really great response rate because it was a pretty long survey, and as I'm going to go through the different topics that were asked, and we're really quite pleased with this. So the survey, like I said, was really long, and we warned our folks that the survey was really long because we had 6 topics. The first was getting a handle on student support programs. And these are the different types of programs that we asked questions about. Next, we asked about recruitment programs that the law schools had, and then also financial support of diverse students. Then we also asked to what extent they had offered competency and trainings for faculty and staff, to what extent students participate in curriculum development, and then also institutional tracking and performance indicators. What I'm going to do is just share some preliminary results on these topics right here. So let's start first with academic support, because this is a really huge issue in retention, right? Like, to what extent do schools offer academic support programs for the purpose of retaining diverse students? So 96% of the law schools reported having at least one academic support program. And as you can see, that this varies only slightly by the 3 different types of law schools. So this is the type of analysis we can do. We can do statistics that talk about law schools in general, and then we can always disaggregate the data by the 3 different types of law schools. And so when I present those results, it's a few times I'll present it disaggregated, and other times I'll present it for law schools, because again, the purpose of this presentation is just to kind of give you an update, little flavor of the types of results that we're generating and exploring. Recruitment programs, 68% of law schools reported having at least one program to recruit diverse students. And by the way, in the survey, we make it clear what we mean by diverse students. So as you can see here, this varies by the type of law school. Actually, it varies significantly here. And so what's interesting about our survey is that every time a school indicated that they had either an academic support program or a recruitment program. So say the first question is, how many recruitment programs do you have? If they said, oh, we have 3 of them, then for each one of those programs, we were asked them to give us details about those programs. So we have a really, really rich data set. Examples of program details includes, well, tell us about your program's goals and objectives, who the target population is, what are the requirements, if any, for participation, what type of outreach do you do to get people to involved in your program, who administers it, do you ever ask for feedback from students, what type of data do you collect on these programs, and how do you measure success of those programs? So again, for every single program that they indicated they had, they were asked these questions. So now let's talk about, just give you a little flavor of some other results. So we also asked, well, what type of non-academic support do you offer? So here's some examples. We asked about, support for student organizations. Do you have wellness? Do you have support for affinity groups? So at this point, these results are for all law schools. What type of mentorship programs do you have? So as you can see, we really teased out the different types of mentorship programs that we know that exist, and we asked about them. We also asked what type of career development opportunities you make available to your students. And so it's ranked here from the one most frequently cited to the one less frequently cited. We also ask about financial support for diverse students. And again, sorted from high to low, financial aid, all the way down to the LRAP. Okay, so that's the survey. Okay, so I'm going to move on and now talk about the analysis that we're doing on enrollment and attrition. Here, we're going to be drawing upon two sources of data. The first is the American Bar Association's what they call their 509 reports, and these are like regular reporting that the ABA requires of ABA accredited schools to report out on their enrollment, attrition, and all sorts of information actually. We're also drawing upon our own internal reports that the State Bar requires of our Cal accredited schools and our unaccredited schools, and we call them annual reports. It's really great that we have these 4 metrics of data: enrollment, JDs awarded, attrition, reason for attrition, and faculty, for race, ethnicity, and for gender for all 53 law schools, for all types of law schools. And one thing in particular we did this year at the State Bar is that we upgraded and changed and modified how we, our own internal annual report for the CALs and the registered schools, and how they reported race, ethnicity, and how they reported gender. And so, in other words, we changed the categories to make them more aligned with the types of racial ethnic categories that we're tracking here at the State Bar, which are actually also aligned with the ABA. So that was a really big lift for admissions, and we're really excited to analyze this data. So let me give you some examples of the types of research questions we're going to be asking of this data that we're analyzing. So for example, one thing we'll explore is how schools vary by race, ethnicity, and gender on enrollment, JDs awarded, and attrition. And then we're going to connect this data on attrition and enrollment, JDs awarded, to the data we have at the school level with regards to their academic and financial support programs. So that's going to be a little bit of a tricky thing, but we're going to try our best to see if we can see any patterns. So for example, schools that have really great attrition, what do their programs look like? And vice versa, like schools that have huge shares of students of color, what do their offerings for diverse students look like? Do you see? So at that point, we're going to try to link the data. And so, that's an example of the type of research we're going to be doing. Okay, I'll hand it over to Crystal now to share with you our next steps for this work.
Thanks, Lisa. So our departments, ARIA, OAI, and admissions are really excited about this integrated approach that we're taking in terms of the law school retention study. Just wanted to give an overview of kind of what our timeline looks like for the remainder of the year, which seems pretty condensed now. So from May to June, which we're kind of in the meat of, staff will continue to do an initial analysis of the survey data, the 509 data, and annual report data, trying to find out any linkages or how the data connects. From June to August, we're going to be integrating our working group. Just to kind of note, Sal, Shalak, and Novella are all members of this working group. We're going to have meetings with them to review the data, share any updates, and then see if there's any additional follow-up needed from the law schools. And then August through September, we're going to finalize the reporter resource guide, which is due on September 30th. Yeah, so at this point, I'm happy to answer any questions about any of the 3 components of this full study as well. Thank you.
Any questions for either Crystal or Lisa?
Heather has a question, and then Michael.
Heather?
I was just going to ask, as you do the research part about the academic and financial programs, are you also going to ask what percentage of diverse students engage in those programs? Not only that they exist, but like, are the law schools actually tracking what the frequency is of the students that engage with them and what the composition of those students are?
Yes, so
Go ahead, Crystal.
yes, in terms of those financial related questions, majority of the survey was focused on like academic support and non-academic support. We had a financial component. We did ask if some of those programs were geared towards diverse students, but in terms of the specific numbers and metrics, I don't believe we have questions as to that level of specificity. Lisa, feel free to chime in if I'm misspeaking.
I was going to say, I don't believe so. I think we concentrated on the academic and the recruiting programs to ask that level of specificity.
Yeah, because I think it would, I mean, if they exist, that's amazing. I'm glad they exist. But if no one either knows to utilize them or has, is being encouraged to utilize them, that would be some, a gap that we'd want to address as well.
Michael?
Thank you for this information. It's really interesting to me. I think I know the answer to this question, but I'm going to ask it anyway. Are LGBTQ folks tracked in this? I think the answer is no. So I'll ask the follow-up question, which is, are we doing anything to gather that data? Because I think that the problem, if I understand it correctly, is that it's not collected in the 509 data, and some law schools don't ask the question, so we have a reporting problem. But my concern is that if we are not prompting law schools to gather the information, then there's no incentive to gather the information. The only source of that type of data that I'm aware of is from the National LGBT Bar Association, which does a campus climate survey, and it's not a full data set, but it's the beginnings of something. And I'd just be curious to hear if there are any steps being taken to move in that direction, so that the problem of not having this information is because no one's asking, no one's collecting.
Lisa, do you want me to take that one?
Yeah, go ahead, Natalie. Yeah, go ahead.
Sure.
I was going to say,
Okay.
you know more of the details of the rollout plan for that.
Okay, well, Michael, good news. There is a 3-phased rollout plan for the internal data that we're collecting. So it was implemented in the first year last year. This year, we are going to be collecting that LGBTQ data. And then we'll also be adding disability and veterans data in the subsequent years. And you raise a good point that there might be a possibility to reach out to the National LGBT Bar as well. First of all, to make sure that they're including our registered and accredited schools, and second of all, to see how we might further leverage this relatively new data set that we get. For some of the registered and accredited schools, they are a little bit smaller and they are distributed around the state. And so to ask more information is new for them. But we got some really wonderful feedback this year when we did the first expansion regarding gender. A gender inclusivity set of categories is planned for next year too. And so when we changed these categories, rather than any students being concerned, the only feedback we got was positive. People said thank you, and they said, we'd love for these gender categories to be more gender inclusive, and what else should you be asking? So we're with you, and so are the students.
Thank you, Natalie. That's really good to hear.
And Michael, do you have any indication as to whether the national board tracks both the accredited and non-accredited law schools in their campus surveys?
I don't know. I know they only have 82 schools. Kristen is shaking her head. No, they only have 82 schools nationwide that completed their survey. I would be surprised if they were reaching out to unaccredited California schools. I can drop the link in the chat if that would be helpful.
Thanks, that would be terrific.
Because I think, again, it's about sharing information, collaboration, not having to do everything from scratch, but really sharing information. So this is great news.
And I'm happy to continue the conversation or be a resource however I can. So please feel free to reach out.
And Natalie, we will definitely forward you Michael's email.
Perfect. Thank you very much.
And just to clarify that the data that the state bar is collecting is just for the California accredited and registered schools. We only gather the data through the ABA 509 schools. We don't collect directly from them.
Yes, that's correct. Thank you, Elizabeth.
And Michael, the National LGBTQA board does the obviously 82 schools within the United States, right?
Yes, that's I believe that they reach out to more than that, but only get about 87 schools nationwide that respond. Not as good of a response rate as the folks that we have apparently in California.
Kristen?
Yeah, so I can also add to what Michael was saying, and and I agree with what he said about tracking the data, and I'm glad that we're doing that. The National LGBT Bar does not send out the campus climate information to California registered and accredited schools. We can certainly, I mean, Michael and I know plenty of people there. We can certainly encourage them to do that if you would, if you think it would be helpful to do that. I know we've talked in the past about, how small some of these schools are, and how some folks, if they identify as LGBTQ, and there are any other identifying factors, it'll be pretty easy to figure out who they are, because there just aren't that many. But if that's something that the state bar would like, can almost guarantee that we can get them to send that. Between Michael and I, we know a ton of people there. So, and I just had one question, and that was on the recruitment programs for a diverse student body. Lisa, when you had that slide up, I was surprised to see that the numbers were small, maybe only kind of surprised to see that the numbers were smaller for the accredited and registered schools. And knowing what I do know about some of these schools, many of them are actually quite diverse, and because of where they're located, and the populations that they're aimed at serving. Do we have a sense of why there is just not more of an effort to recruit diverse students at those schools?
Or Lisa, may I share a bit?
Go ahead.
Or Natalie, who, sorry, Natalie.
No, it's fine. So part of this is that some of those schools, especially being smaller, would say that they have a total single recruitment plan that's designed to be diverse at every level. And so they wouldn't have a specific targeted program because that would describe their whole program. And that was something that we learned as the survey was being answered. And so we may want to think about how we refine future questions to still get information about what their internal practices and the recruitment practices are.
And maybe if we had the raw data, it would help us understand a little more. For instance, how many unaccredited law schools were participating out of the X number that is out there. And maybe we just need a little bit more of the raw data to kind of understand where these numbers are coming from.
Yeah, and here in some cases, when they said, do you have a program for recruiting diverse law students, because it wasn't specifically targeted, they said no, and then closed off the question. So with the benefit of hindsight, it would be helpful to ask in the future, okay, can you tell us about what your admissions and recruitment practices are? And that would be helpful. And we may be able to pull some of that from their compliance reports to enrich the study findings.
And I would also add that this law school survey has a mountain of narrative data that we are combing through. So we may also be able to get at that through that review, but it is taking staff quite some time because there is a lot of narrative to review.
So for example, one of the questions is, do you have a diversity mission statement? And so many schools shared that. And so that would be one place to look. So for the schools that said that they didn't have a program, well, let's look at what they said about their mission statement. And if, yeah, we have a few other questions that were really upfront, that weren't limited to programs or non-programs. It's like, just tell us like your ethos, just tell us, or that are meant to get to that, like their overall feelings about diversity.
Any other questions?
Any other hands raised, Judge Esther?
Okay, thank you. Let's move on to the update on our report to legislature. And thank you to Ryan. Ryan and I combed through pages and pages of this report, looking at it in fine print. So thank you to Ryan and Elizabeth.
Okay, so I'm going to share my screen and just briefly run through the presentation on the report that we submitted to the legislature on diversity, equity, and inclusion. This presentation was provided to the Board of Trustees last week, and I'm just going to run through it very quickly because our meeting today, we've already received very thorough updates on many of the topics, or will receive very thorough updates later in the meeting. But I wanted to give you the framework of the report in case you haven't yet had a chance to review it yourself. And again, echoing Judge Esther, I want to thank Judge Esther and Ryan for their time and really thoughtful comments as we were drafting the report. With all of our attachments, it was 172 pages or 174 pages. And they were really very, very, very thoughtful with their comments and helpful in helping us to articulate the real good work that we're doing, as well as articulating plans for the future. The Diversity, Equity, and Inclusion report that we submit to the legislature is a biannual report that we submit pursuant to Business and Professions Code 6001.3. And that statute requires us to develop and implement a plan to demonstrate the State Bar's ongoing commitment to and support of policies and activities to enhance access, fairness, and diversity in the profession and elimination of bias in the practice of law. As I mentioned, we submit this report every 2 years, beginning in 2019. And the plan may also include an assessment of needed revenue, which we did not include in 2019, but did include for 2021. And I actually want to thank Ryan for encouraging us to really flesh that section of the report out. And so the report really centers the State Bar mission and our strategic plan. And as many of you know, the State Bar mission was amended in 2017 to include support of efforts for greater access to and inclusion in the legal system. And then the statutory mission was also amended in 2019 to effect the same. And then I think all of COAF is very familiar with the strategic plan goal for objectives G through O. This really drives the work of COAF. And I think every single item, every bullet point on this list, COAF members have had working groups and have discussed. So I won't spend a lot of time here. Other to note that these objectives were developed in 2019 by the Board of Trustees with a lot of feedback from stakeholders, including COAF. And at that time, the board was really trying to determine how best to advance the work of diversity and inclusion as a regulatory agency, and made the strategic decision to focus on pipeline to the profession beginning in law school, retention and advancement in the profession, as well as judicial diversity, and really wanted to focus on those areas because they thought they, as a regulatory agency, the State Bar could be most impactful. So the report is organized into these 5 areas, and I will go through them again quite quickly to just highlight the activities that we've done in the last 2 years. And then I will highlight the activities that we have planned for 2021 and 2022. So as you all know, there is the attorney census that is a survey that we administer annually with the licensing fee statements. And so from that, we gathered the data for our diversity report card, and we had a working group who helped us with the first annual report card, which I believe was Ryan and Sal. And in those report cards, we have calls to action where we really are trying to encourage employers and attorneys to think about diversity, equity, and inclusion in the profession and to make efforts to advance it. We also have our diversity summits, which COAF helps to develop and plan. And we've, I think, successfully, focused on sector-specific summits in 2020 and again for this year. And we've also had the opportunity to share the report card and our census data widely with local bar associations and affinity bar associations and at conferences. And then the second area is creating a culture of diversity. And so I think you've all heard that the State Bar has a built-in, not bolted-on approach to diversity, where we hope that diversity, equity, and inclusion will be, a through line throughout all of our work at the State Bar. And so we are focusing on, staff DEI work, which includes implicit bias training for all staff, as well as a lot of DEI staff resources, beginning conversations with staff and providing space for staff to be able to talk about those issues and feel comfortable doing so. And then, as all of you know, we have been working, COAF has been working on the enhanced MCLE for active attorneys. So those efforts resulted in doubling the elimination of bias requirement from 1 hour to 2 hours, and with one of those hours being required to be implicit bias. So that rule was adopted by the Board of Trustees last year. And currently we have a COAF working group who are helping to develop a 1 hour implicit bias training, which will be available for free to all attorneys on the State Bar's e-learning channel. So that we hope to be available later this summer. And I want to thank Judge Esther and Novella for all of your feedback and help working on that. And pipeline to the profession, we had our really thorough, excellent presentation on law school retention efforts. We will also have an update later today on the DIF working group, differential item functioning analysis. So with the bullet regarding improving performance on the bar exam, the California Bar Exam Strategies and Stories program is an intervention that has been implemented in the 2018 and 2019 July exams, which showed a great probability of passing the exam was higher for those who participated in the program. And so that was very promising. The study, we were working with a group of researchers from Indiana University, Stanford, and USC on this intervention. And they found that pass rates improved for underrepresented minority bar takers by an estimated 16 percentage points. And the probability of passing for first-gen bar takers was also higher. And so this intervention was also offered in the October 2020 exam, I believe the February 21 exam, and will be offered this July as well. And so we're very excited about that. The Office of Admissions also worked on modifying the moral character determination process. There was an ad hoc working group that finalized 3 documents to help make the process more transparent. And that included developing a moral character statement, a moral character determination guidelines, and best practices and talking points for law schools. And those 3 documents were approved by the Committee of Bar Examiners last April, and then approved by the board in May 2020. And so we've talked about diversity summits, and we had the update on the racial disparities, the work being done to address the racial disparities in the discipline system already. And then with promoting judicial diversity, in 2019, COAF worked very closely with the Judicial Council to update the Judicial Diversity Toolkit, and we continue to be available to the council at their request to participate in any activities. And so looking forward, We're working on our second annual diversity report card, which we plan to have published online in an interactive format. We received a lot of feedback that it would be helpful if we could look at the data in a lot of different ways. And so we hope that this interactive format will allow that. So if you're at a large law firm, you would maybe be able to zero in on what other large law firms look like. Or what other large law firm attorneys' satisfaction may be. We're also working on sector-specific calls to action, and we have a bunch of co-op members working on all those. And at the risk of not including everybody, I'm just going to thank you all right now for all of your hard work on that. We're really excited about these calls to action, and so the plan is to have all of that published next month. And as you all know, we have the 2020 impact survey, which focuses on the impact of both the COVID-19 pandemic and the increased national emphasis on racial justice. We are in the midst right now of diving into all that data, and we will be publishing those findings later this year. And then for diversity summits, next week is our government and public sector summit. And so we hope that, if you're available, you'll be able to join us. And we will also be planning additional convenings to share out the report card data and impact survey findings for later this year. We'll also hope to work with local and affinity bar associations, to hold their own events on a localized level. One of the more significant projects that we hope to work on, that we plan to work on this year, is what we're calling the DEI, Diversity, Equity, and Inclusion Leadership Seal program. And this is a program that we hope to implement to encourage legal employers to set and publicly commit to measurable DEI goals. And so our thinking is, at first, these goals may be aspirational, but over time, we hope that the employers will be able to implement actionable measures to demonstrate their commitment to and their progress in diversity, equity, and inclusion in their workplaces. And so we plan to launch this later this year. The agenda item immediately following this report will be potentially amending the co-op's work plan to include working on this initiative. And we've already heard about law school retention, so I won't go into that. And then with the California Bar Exam Strategies and Stories program, as I mentioned, it's been very promising. And so we've been working with a group of research on it, and that's how it's been funded until now. And we're hoping moving forward to seek permanent funding to institutionalize the program for the February and July bar exams annually. For retention and advancement in the profession, we are also looking at an active attorney study for this year. As some of you may know, national data suggests that women of color, particularly Black women, are highly likely to leave the profession within the first 10 years of practice. And so we are looking to see what California inactive attorneys look at what their demographic and professional characteristics are, who move to inactive status, and then potentially to look at what interventions and supports might be available. And then we've had our update on the attorney discipline system already. And then we'll have an update later today on studying the viability of loan repayment assistance programs and loan forgiveness on recruitment and retention, particularly in the nonprofit and public sectors. And then again, we continue to remain available to the Judicial Council in their efforts to advance judicial diversity. And then here is information about the funding history and potential funding needs. So currently the primary source of income or revenue for this work at the State Bar is the elimination of bias opt-out fee on the attorney licensing fee bill. And that is a $2 fee per attorney, and it's optional. generates approximately $300,000 annually, and it currently supports staff in the Office of Access and Inclusion, the work of COAF, and our existing initiatives. We've identified some potential funding needs. Potentially, once we are complete with our law school retention study, an evaluation of law school retention initiatives, which would be a one-time cost, ongoing outreach and communication support to share the state bar data, support for local and affinity bar associations to hold localized summits to replicate our statewide convenings, and then 2 administrations of the Strategies and Stories program. And then should the ad hoc commission on attorney discipline and the board approve this, a potential pilot of state bar appointed counsel for income qualified attorneys in the attorney discipline system. And so that is my presentation. Are there any questions? Okay. Heather?
That was excellent. Thank you so much. That was amazing. The last part about the fees, I wonder if there's a way, so like at my company, we are instructed to not opt in to any of the optional fees as they pay our bar fees for us. But I wonder if now we should be leveraging a campaign to encourage companies to opt into that fee as part of their commitment to diversity. I certainly am happy to take that back personally to my company, but I think there's a larger marketing program here that we could just push. I think that's just an oversight. That's a really simple oversight that I think maybe we could leverage and take advantage of. So just food for thought.
Yeah, that's super excellent. And I know, Donna, we've talked about this. We've gotten feedback that attorneys just haven't realized that, because they don't really see their fee bills. And so that is something we are going to look into, because I think, a lot of attorneys would want to support this work.
And even just the way it's structured, like I'm using my corporate card to pay my fees. So if there was a way that I could just pay that and then separately pay my own contribution, even if my company didn't do that, to make that easy would be a second option. So
yeah, that's one of the things that we're considering, Heather. That exact point is really sort of advertising for folks, if sort of making the pitch to the agencies that pay for their attorneys, but also really streamlining the ability. There are certain things that you can do online, but if you don't know exactly where to look, and you don't realize that you don't intuitively know, hey, if your firm is not paying this, you have the ability to do so, click here. So just making that easier, streamlining that a little bit. So we've been thinking about the very same things.
Love it. Thank you.
And I would also add that most government agencies will pay up to $100 for any additional bar organization fees or any specialty bar sections, and they would certainly be more than happy to pay the few dollars in lieu of any other sections or any other bar organization. So that's something that we can take back to our government offices, anyone that is in government, because they really do add up. And as everyone saw, it's 170 some odd pages of the good work that COAF has done and all the other diversity initiatives that the State Bar has implemented. And what I was the most proud of was the fact that, we always talk about during COVID being able to pivot and being leaders with regards to diversity and inclusion efforts. And as you can see, a lot of the work that we have done and have completed within a very short period of time includes really addressing that key period of the pandemic, how that has affected, what we can do better. And so I was really proud to read the report and all the good work that we have done and to present that to legislature. Any other?
And I would just echo the thanks that Elizabeth mentioned at the start of the presentation and really throughout. Judge Esther is right. If you read the report, it really is a testament to all of the work that all of you have been doing. And so, much thanks to all of you for doing the work, and much thanks to Ryan and Judge Esther for really helping put together that report and being able to showcase it. I think it really is, it really was a great work product. So thank you all.
And thank you to the staff. We could not do any of the work that we do without you. We are a much smaller committee than we used to be. And so in reading the report, I was really amazed at how much we were able to accomplish despite the council being much smaller than it used to be. But again, I think it's a testament to staff and to all the leaders at the State Bar, because again, we could not do this without you. So thank you. And any other questions before we move on to our work plan? Okay, so let's move on to our work plan. And this was the seal that we were very excited to discuss at the last meeting. And so we're going to review the COAF work plan, which was approved March of 2021. And we wanted to add an addition, which is the implementation of the SEAL program that we discussed at the last meeting. So Elizabeth?
Yeah, so I've just shared my screen. Hopefully you can see, this is the COAF work plan that you all provided all input on, I think, at our December meeting. Yes, at our December meeting. And it was approved by, as Judge Esther mentioned, it was approved by the board in March. And with the, but we did not have the leadership seal program in our work plan. So if COAF is agreeable, I would like to have that added. And so it's under objective L, which is to identify particular obstacles to diverse attorneys' entry into, retention, and advancement in the legal profession. And so this is the language that I put in to provide feedback on development and implementation of the DEI leadership seal program.
And let's open it up for discussion or questions that anyone may have. And just as a refresher, this is the SEAL program that we discussed at the last COAF meeting, where we would have a stamp or a seal of approval almost by the State Bar. We'll work out the logistics, but that is really something that could be used as a publicity tool or as a tool to advertise, and the commitment to diversity for the different law firms, agencies, offices, etc.
Sarah has a comment.
Sarah?
Yes, I know the ship has sailed, but I just wanted to reiterate that I just don't think this is a good idea or a good use of the bar's resources. I know the ship has sailed, but you know, I haven't changed my mind about it. You know, my current position, I do a zillion surveys from a lot of different organizations, and I'm just not sure that adding to that is really going to result in meaningful change. And so, you know, I just wanted to say my piece, and that's it. I recognize everybody else has moved on with it, but that's just my piece. Thanks.
And thank you, Sarah. I think it's important that we hear all viewpoints. And I remember at the last meeting, you had concerns with regards to just having this inundated different programs where we kind of use this as a PR tool. So any other concerns that COAF members may share? And we are going to take a vote to determine whether or not we want to include this into our work plan. Do you see anyone else, Elizabeth?
I don't. No, I don't. But it's hard for me to see everybody with my screen share. So Kim, do you see anybody else who has a comment?
No, I don't.
Okay, thank you.
So at this time, I need a motion, and the motion will be to add to the work plan the DEI SEAL program, the Leadership SEAL program, and I also need a second before we move on to a roll call vote.
I move to approve.
So Ryan moves to add the activity to the work plan for 2021 and going forward.
Yes.
And do I have a second?
I second.
Heather seconds. And let's take a roll call vote.
Judge Esther?
Aye.
Ryan?
Aye.
Heather?
Aye.
Novella?
Aye.
Sarah?
Nay.
Michael?
Aye.
Shalak? Kristen?
Aye.
Stephanie?
Aye.
Sal? The motion carries.
Thank you, and it passes. And at this time, do we need to create a working group, Elizabeth?
Yes, we do. Thank you. So I would like some volunteers to work with staff on the development and implementation plan for the leadership seal. I see Ryan and Heather. Great. So, and Michael.
Michael.
Okay, great. So I will be in touch with you to move that project forward. Thank you.
Thank you. And moving on to our update on the Diversity Summit, which is just around the corner.
Oops, yes. So our Diversity Summit is next for the government and public sector is next Thursday. So if you're interested in attending, please register or let me know and we can have staff register for you. I really want to thank Kristen and Michael and Stephanie for all of your time and brain power in helping us develop our agenda for it. We have a really, really exciting panel, which Judge Kristen is our moderator. I told her she can just treat it like her courtroom. You know, I'm very excited about our panel. We have Tracy Davis from the SEC, Chris Areola from the Santa Clara County District Attorney's Office, Kamal Chokshi from the University of California, and Donna Hershkowitz will also be on the panel. So we are really excited about it. And I think it'll be a great event. We're also going to have breakout sessions similar to our private sector summit. So I'm hoping to really engage folks. And so if you have any government or public sector attorneys in your network that you want them, think they might be interested in attending, if COAF members should have all received the invitation. So you can just feel free to forward that or let me know and I can forward the invitation to them directly.
And Elizabeth, when is the deadline for everyone to register?
We set the deadline for today, but because it is a Zoom event, we can definitely take registrations, up till Thursday. Thank you.
So please share that with your networks. And any further questions on the summit that's coming up? Okay, seeing none, we'll move on to an update on our impact survey of 2020.
Yes, thanks, Judge Esther. So I talked about it a little bit in the report to the legislator. So the impact report we had open in April, and we also closed it in April. It was open for 2 weeks. There were approximately 10,000 respondents, which I understand is typical of a survey of that nature for the State Bar. As I mentioned, we're in the midst of reviewing and analyzing that data and plan to publish that report later this summer. I would also like to ask at this point for volunteers for a working group to work with staff after we're done analyzing data to look at the findings and to shape what our report might look like. Michael, thank you. Okay, if I will reach out to others for volunteers. We do have a couple of COAF members who aren't present today. But we are excited about this report. There have been several pandemic focused reports published recently that we are also looking at. But I do think our data set is going to be able to particularly show the impact on solo attorneys in California. And so I think that will be an interesting addition to kind of the discussion on the impact of events from 2020.
And Elizabeth, didn't we have a new rule that if you don't show up to the meeting, you're automatically in the committees?
I think so.
Just kidding, everyone.
I will let Sal and Shalak know.
Welcome to the working group.
Yeah.
Any other questions before we move on to our next topic? So let's move on to the update on our CS BAR's proposed rules regulation.
Yes. So I wanted to let COAF know that the Board of Trustees adopted the rules for California accredited law schools at their May 13th meeting. The new rule will go in effect in January 2022 and really focuses accreditation of California law schools on essential purposes and incorporates best practices and provides a framework to recognize law schools that are accredited by region or national accreditors. And the rules really focus on 4 areas: consumer protection and transparency, student success, diversity, equity, and inclusion, and preparation for licensure and professionalism. And I want to thank Kristen and Sarah for their participation in reviewing the rules and providing feedback and discussing with CS BARs their concerns, COAF's concerns related to the DEI section. I think how the final language that was adopted by the board really showcases the really thoughtful discussion that we were able to engage with CS BARs with. So I want to thank them again, because it was you know, an area that neither Kristen nor Sarah had a lot of experience with, but they really jumped in there and learned a lot about it and provided really great feedback.
And there was a wonderful article. I received a copy along with Sarah and Judge Kristen, but Elizabeth, can we send it to the entire COAF council? There was a wonderful article about the great work that Judge Kristen and Sarah did on this board. So that was an email that was sent to both myself and to Kristen and to Sarah, but we're going to forward it to the entire council so that you can have an opportunity to review the article. So moving on, let's
Judge Esther, can I just jump in real quick?
Yes.
I just wanted to also thank Natalie for her patience with Sarah and I as we continued to raise some of the same issues over and over again. And she patiently talked us down and helped us work through all this stuff. So I wanted to make sure that we didn't forget Natalie on this.
Yeah, I just wanted to say Natalie and Elizabeth were wonderful on this, and thanks so much for showing the newbie kind of how California accreditation works, which was completely new to me. So thanks so much, Natalie and Elizabeth, and of course, Judge Kristen too.
Thank you, everyone. So let's talk about the update on the bar exam question development and grading.
So I think that Heather, you are going to present on behalf of the working group.
Yes. Hello, everyone. Oh, wait, I've got to reduce my screen so I can get to my notes. So the working group is comprised of myself, Shalak, and Sal, as well as Doan from staff. And we had our second DIF working group meeting on April 14th with Scantron reps who came and presented guidance to us on how to interpret and recognize potential bias in the exam questions. And this was a result of a request from our first DIF meeting where we felt like we still couldn't interpret the information that was being presented. So we wanted kind of a deep dive in a little bit more nuanced explanation into how the bias was showing up in the potential exam questions. What was enlightening from this second meeting was that there's the potential bias that comes from out-of-state test takers, and that certain subjects are more prone to bias, such as community property, which is California specific. And so what we decided from receiving that information, which was much more complex and nuanced than I would have ever anticipated. I actually thought it was just, we were going to, suddenly see like what everyone had been missing, that it was going to just be clear. And instead it was still very muddy. And so we are going to meet in advance of the next DIF meeting to review 10 to 15 exam questions and the specific topics that seem to be more problematic. And I'll just back to my notes. I feel like community property, I want to say evidence was flagged as one as well. Or maybe I wrote some notes about ones I thought might be problematic. Professional responsibility and torts, I think, were two of the examples too. And then we're going to try to develop some best practice guides on how to prevent future bias in exam questions. Some of the things we were looking at, in addition to the out-of-state diverse candidates, and what they might not be familiar with, because what Scantron pointed out was some regional change, language that might create bias too, that I would have never been sensitive to before. But also how much people may be utilizing bar prep and trying to get, we're hoping we can get some research. I don't know, because we're kind of working with older information and trying to apply it currently, but maybe going forward, keeping track of how, if there's a correlation between people having bar prep and therefore some exposure to some of the regional differences prior to the actual exam, that we might be able to target. So we'll dive into that as we review these exam questions and as we start to try to develop best practices.
Any questions for Heather?
So I think just one clarification, Heather, if I recall the specifics of this study, there weren't any subject matter areas themselves that as a whole showed differential performance, but rather there were specific questions that crossed multiple areas. So there may have been a torts question, a community property question, that, as you indicated, but there wasn't a finding that community property questions themselves had disproportionate performance.
I think that's right. Like I said, looking at my notes, like I don't have a lot of clarity about why I wrote down what I wrote down, but I think that's correct.
And I, again, sort of tying back to the prior discussion that we were having on the discipline system and your input on that, this really will feed very well into the Blue Ribbon Commission on the future of the bar exam. And let's see, Ryan, I think, is on that, and is it Kristen? And Kristen. So any feedback that we can have during this process that goes to how to better shape bar exam questions will be great information that they can feed into that Blue Ribbon Commission.
Excellent.
Kristen has a question.
I do. I do, and now Heather has to answer because she's the only one here.
Right.
So I'm just wondering, like, you're on the spot. So do we know how many out-of-state takers there are, and do we know much about these folks? If when it comes to the differentials.
I'm thinking Donna may have more of an answer than I do. I don't recall them giving us the statistics on that. I just have a big asterisk around it, like it was pointed out.
Yeah, and I think the findings were that California ABA bar takers had a higher success rate than out-of-state ABA schools, because I think the analysis was out-of-state and in-state schools, and then ABA schools with other schools.
Okay.
But we don't have the breakdown, the specific breakdown that you're asking for.
Okay. Okay. And the other comment I was going to make was that I thought this would, this is obviously really important work, especially as we tackle, where we go with the bar exam from here. So awesome work.
So I had just a meeting just to get feedback from Chancellor and Dean David Fagman over at UC Hastings, and he spent quite a amount of time talking about research that is currently being undertaken in the state of Nevada and their bar, because they have more access to information about the bar exam and the people taking the exam. And I guess the issue that the study is focusing on is whether or not the exam actually tests the candidate's ability to perform legal functions in the real world. All right. Dean Fegman believes, and I kind of agree, that maybe these folks who are doing this research should be able to present that to either the Blue Ribbon Commission and or COAF. They may not be able to complete the study by the time the Blue Ribbon Commission completes its work, but there is a lot of information that they already have in their possession and can report on that might be informative.
Thanks, Ryan. I think we can take that information to the staff working on the Blue Ribbon Commission as a suggestion.
Okay.
Any other comments or questions? Seeing none. An update on our implicit bias training.
Is there? Oh, good, great. Erica Carroll's here to give that update.
Thanks. Good morning, everybody. So just a quick update on the implicit bias MCLE, the elimination of bias curriculum. As you know, there were approved changes to the state bar rules last year to incorporate specific coursework or curriculum related to implicit bias, and the board also approved the development of an online course. And so we've been working with our developer and our content expert for several months on creating that course to assist attorneys in meeting this new requirement that hasn't yet gone into effect. The course will be ready when it does next year. And so I believe at the last meeting, we were still in the phase of gathering content and refining the content and narrowing down the topics given the limited time that it's a 60-minute course. But I'm happy to report that we are now at the storyboarding phase. So we're moving forward, and the course has 3 modules. The first module is understanding implicit bias and microaggressions, as well as its impact on the legal system and the legal workplace. So, it really is intended to help the learner understand sort of the broad impact of implicit bias in the court system and undermining confidence in the court system, as well as the impact on legal professionals as well. Then the second module gets more into specific types of implicit bias and various scenarios for the learner to go through to understand its application. And we also have a module related to managing and disrupting bias, both on the individual level as well as the organizational level. And not only disrupting bias within ourselves, but also helping the learner think through some ways to respond if they are impacted by bias, or if they want to serve as an ally when they witness an instance of bias. So those are kind of that's the main overview of the course so far. There's also a post-assessment for learners, and we've learned from the developer that we will be able to do some data analysis on the back end of things like how many tries it takes to get through the post-assessment, how long it takes. If there are questions, for example, we can identify that maybe need further clarification or to be updated in future iterations of the course. So we're excited to have that functionality already built into the course. So currently, as I mentioned, we're at storyboarding. We'll move into an alpha version of kind of getting to see it in real time in the next few weeks, and hoping to finish and have it finalized in summer, probably about mid or late July.
Any questions with regards to the implicit bias training? And the next course that the working group will consider is the anti-racism component of the EOB curriculum. So the working group, which is Erica, myself, and Novella, will be looking into those issues as our next phase of the EOB curriculum.
I had a quick question, Judge Esther. Erica, will we get a chance, will co-op get a chance to see the MCLE implicit bias before it gets rolled out?
I think, I don't know, Elizabeth, do you know if we'd be able to share, like if it's.
We could probably share with the working group the alpha phase. I forget the alpha version.
Yeah, the
of
alpha version.
Of the module with the working group to provide feedback at that juncture. We've already had really great feedback from Judge Esther and Novella on the course content. So yeah, the working group will be able to see that.
Anything else? And moving on to our last subject before we break for lunch, the update on the loan repayment program.
I think that is Judge Kristen. Let me show.
It is, and I know that's a bit longer, so if you, I don't, it's a little bit longer report than the others, so if Judge Esther, you wanted to break now, we could, or people want to sit through this before lunch, I'm happy to do whatever.
What is the time estimate?
Elizabeth, did you put a time estimate?
I put the time estimate at 15 minutes.
Is that about right?
15 minutes, yeah.
Probably. I can be less long-winded and make it.
Well, it's almost 12. So yeah. Since this is a very important topic, why don't we wait until after lunch so we can break now for lunch, and let's have everyone come back at 12:30.
Great.
And we'll shoot for 12:25, give a few more minutes for everyone to come back, but we'll start promptly at 12:30.
Okay. Great, thank you.
Thank you, everyone. We'll see you in a bit.
Judge Esther, it's 12:30 now.
And we have quorum?
I see 6 members. So we do have quorum.
Okay. And I think most of the votes have already been taken for the action items.
Exactly.
So we're back after lunch, and let's pick up where we left off, which is Judge Kristen. Give us an update on the loan repayment program, please.
I would be happy to. Thank you. So as a reminder, Heather and I, along with many other people, as you will see in a minute, have been working hard on the retention issue as it speaks to loan repayment and loan forgiveness. You can forward that. So we have a working group, and I want to say this about the working group. It is comprised of folks from a variety of different stakeholders with experience all over the board. And I think that that makes us a really powerful and really interesting group. There are folks from the California Access to Justice Commission, including their chair and vice chair, and Judge Yu, who is actually a representative or to a liaison to COAF, is also on there. Heather and I, of course, and then folks from the Legal Service Trust Fund Commission, including their chairs and co-chairs. and then State Bar staff that have worked extremely hard on this issue. So as you can see from the slide, we've met 3 times so far, and can share with you a little bit about where we are. Yes, so we've taken a look at loan repayment and loan forgiveness issues both here in the state of California and outside the state. As many of you remember, there's a federal loan forgiveness program that we talked about quite a bit. And we have researched some opportunities to make federal public service loan forgiveness more effective. You heard that from our first presentation that 99% of folks have been denied in this program. One of the things that we're doing now is we're starting to talk about as a bond forgiveness. But so let me back up a little bit. As a reminder, the California Student Aid Commission administers the California Loan Repayment Program. The program has actually existed for about 20 years or so. It has never been funded. So it exists there by statute, but it was never funded by the legislature. In 2015, the escheated interest from IOLTA accounts, money was allowed to be put into LRAP programs. I'm not entirely sure where that money is right now, and maybe Elizabeth can give a better idea where that money is, but it appears that there's about $1 million out there somewhere in escheated IOLTA funds.
Yeah, and I think Erica can tell us okay, that issue. Tell us more about that issue.
Yeah, Erica, do you know, can you remind me where that money actually is?
Yes, the money is still currently held by the controller's office. My understanding from the last update is that it does need to be transferred to the Treasury. They're in the process of setting up the necessary accounts for that to happen. So the money that's accumulated over the past 5 or 6 years is still held by the controller.
Okay, great. So there is no, so it hasn't obviously been transferred to the Student Aid Commission. And there is no mechanism at this California Student Aid Commission right now to even administer the money were there to be money. The program as it was set up is limited. I think it limits a couple thousand awards annually, and then you can only I think you can only, remind me, is it $10,000 or $11,000 that you can get as lifetime assistance. Yeah. So for folks who remember, Heather and I spent quite a bit of time talking about how much money is owed by folks when they leave law school, and those numbers in the average is somewhere around 160,000, but most students of color owe somewhere in the neighborhood 200,000. So 11,000 lifetime doesn't really move the needle a lot. And again, there is no mechanism right now to even administer the $1 million or so once it's actually transferred somewhere. So we talked about repayment versus a loan repayment program versus a loan forgiveness program. Loan repayment makes it easier for people to pay it off. Loan forgiveness is a little bit like that federal program in that it actually forgives chunks of what you owe every year. We talked about what we thought was viable in California, given that we already have a statutory LRAP program. That seems to be a more viable option. We also discussed that there is a federal program out there that does, in theory, give loan forgiveness. And while it hasn't really worked for anyone yet, there is, the potential with a new administration that it might. So we've really spent most of our time focusing on how to make a California LRAP program workable and feasible. And so, as it says there, and then we've discussed bond refinancing for public interest lawyers. And I will do my best to explain this. I feel like I should have taken a class or a refresher class in economics and banking to really understand this. But as Jack has explained it to those of us who don't know financing as well, the idea is that there would be a bond defeasance program set up, and it would be a way of helping use public refinancing, basically, of the student debt. And how it would work is that the state would issue bonds, which folks would then buy, and that the money that was used to buy the bonds would essentially help reduce the interest rate that public service lawyers were paying on their own student loans. So because the bonds are tax-free, that it would help basically lower the interest rate that folks were paying on their student loans, which would then ultimately down the line lower the amount they were paying. So it doesn't touch principal. It doesn't touch the principal that you've borrowed, but it does help reduce the amount of interest that you're paying. And for those who have student loans, you know that a lot of the time you're just paying off interest. So it would help in that way. And I think I did a pretty close job of explaining it, right? Without Jack being here to really dive into the numbers. That's how I understood it. And so that's one of the things we're looking at. So I guess if you want to flip the slide, Elizabeth, so we've decided at this point basically to work on 3 different strategies simultaneously. We're going to work on how to operationalize the California LRAP that exists right now. Many of you have heard me say already that I believe it shouldn't be with the Student Aid Commission, and that it would make a lot more sense if the state bar were administering the LRAP program. That's what most state bars do around the country. The other state LRAP programs, most of them are administered by the state bar. I think it makes more sense for the state bar to do it than the Student Aid Commission, especially since the Student Aid Commission hasn't been able to come up with a framework to start working on that in the last 20 years. And then with regard to that this is the other piece that Heather and I have talked about, how to actually fund this California LRAP that already exists. So we're using the escheated funds, which is great, but are there other ways that we can get folks involved? Can we get philanthropic donations? Can we make this part of corporate giving? Is there a way to get more money in there to actually help move the needle for all of the attorneys in California who are doing this work? So that's one sort of prong we're looking at. The second is this bond issue that I just tried to explain to everyone and maybe did a decent job doing. Can we get that moving? And so one of the things that we're doing is surveying public interest attorneys about their debt. The state bar staff has been working, it feels like nonstop, to get this survey ready and out. And I believe it's going to go out in the next couple of weeks. Just try and get a sense of what kind of debt is out there, how much they owe, what their interest rates are, so that we really know whether this bond defeasance will make a difference for folks. And whether they have the ability to refinance and all these kinds of things. And then the third thing that we're looking at is really this, there is public service loan forgiveness out there on a federal level, but it's been completely ineffective. It has not helped nearly the people that it could help. And is there something that we can do to help on a federal level to get that program up and running? And other members of our working group have connections all over, the federal government, Department of Education, things like that. So they are working on, is there a way to move this administration on this issue and make sure that that the applications are being processed quickly and fairly, and people aren't being denied loan forgiveness when they certainly qualify. So those are, our three multi-pronged approach. We are, it says that in June, excellent. In a couple of weeks, the survey is going to go out. And again, thank you to the State Bar staff that have put that together. And then the working group will continue to meet and make recommendations to COAF and Law School Trust Fund and all these kinds of things. So really from the moment that Heather and I started talking about this to just a few months later, I feel like we've moved so far so quickly. And again, that has so much to do with the State Bar staff that are working on this, Elizabeth and Erica and Chris and Dwan, and it feels like everyone at the State Bar is working on this. And so we are so incredibly grateful and thankful at how quickly we've been able to put this in our work planning and get it moving. So I'm happy to answer questions. And then Heather, if you have, if you can do a better job explaining bond defeasance, please.
I was just going to say, you explained that way better than I could have ever explained it. Excellent job. And I echo everything you said. I only wanted to say, I mean, it really is amazing the depth and breadth of experience and connections that the working group has, and combined with the strength of the staff, it's been an amazing project to work on. With respect to the bullet point about looking at additional ways to finance the fund, I think one of the working group members, or two of them, were also going to reach out to the California Bankers Association to start to have those conversations with financial institutions about how, which was one of the things Kristen and I had talked about with respect to tapping into social responsibility initiatives or DEI initiatives that those institutions may have. So we thought, instead of kind of piecemeal contacting individual financial institutions, the right place to start those conversations would be with the California Bankers Association.
I see that Michael has a question, and then Novella.
I do, and I hope I'm not getting too into the weeds. It has to do with whether or not the bond refinancing plan would have the potential to touch private loans as well as publicly held loans.
It was my understanding that it would be focused on public loans.
Yeah, and we did. I mean, that's part of the survey. I think is we're asking as part of the survey, how much of your loans is being held public, and then how much of them are private, and then asking sort of the interest rate. But I think right now it is focused on the public, just because that tends to be the first chunk of money that folks are looking at. But we absolutely have talked about how, especially for students of color, the public limit, public loan limit is insufficient to meet the obligations, and that lots of students of color are using private loans as well, and those frequently come at a much higher interest rate.
Oh, and Erica just corrected me. It's actually private loans.
Yeah, there is some aspect of, a lot of the public loans, in the event that public service loan forgiveness is viable, borrowers would not necessarily want to refinance those loans, because then they will no longer be eligible for the loan forgiveness. So it is both public and private, and in fact, maybe, we don't know yet, but maybe more beneficial for the private loans in terms of having an option to refinance at a much lower rate through the state.
And I should also
Thank
say, I think that there was some question about whether we needed legislation on this, right? I think that's sort of an up in the air thing about whether we needed.
On the
whether
bond
there-
initiative?
Yeah.
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 I think so.
I think Novella had a question.
Yeah, I got the survey within the last week and it was great. So I really appreciate those who put it together. And it was just like, I could see how the types of questions would generate helpful information for figuring out how to solve this problem. So that was awesome to get and to fill out. Yeah, it was great. I also started thinking just more on the front end, especially as you guys were talking about the difference between public and private student loans. And so I don't know too much about how law schools are financed, but I'm just wondering like what could be done on the front end to prevent the like amount from being so huge and overwhelming and like limiting your life choices in all the ways that the survey identified. And I saw in the news very recently that like the NAACP Legal Defense Fund had like secured through fundraising efforts, I guess, like a public interest loan program where students would make a commitment to public service on the front end, and that would finance their help finance their law school education and like all of the ancillary expenses when it comes to summers and stuff like that, so that they could like stay in the South doing public interest work for 8 years after they graduate. And I know I brought this up before, Harvard had a similar thing where it was a pilot program, but if you committed to do 5 years of public service, then they waived your third year of tuition. And so I took advantage of that. And I think because of that, I hardly had any private law school loans, and that made a huge difference. But I imagine getting that money and like getting law schools to like waive or reduce tuition or like securing the fund on the front end, there must be like some issue there that I don't know about.
I will say that, you know, that there, I have spoken to folks at financial institutions about, you know, what we're proposing, and I have heard something very similar to what you're saying, which is, well, why does law school cost so much? I mean, you know, in talking to sort of, you know, to some of my sort of banking friends, they've said, well, you know, if we were to get on board with this as a bank and donating to LRAP and these kinds of things as part of our social justice, that's what we're doing. But what about, you know, what about the law schools themselves? Why is it so expensive to go to law school? Why, you know, why is there this, you know, huge, you know, this huge, what is it, 75% increase in tuition over like a 5-year period? Why is that? What are the students getting, you know, from that money? And why are you asking us on this end to help fix a problem that maybe the law schools are part of the problem, you know, contributing to the student loan problem itself. And that may well be when Heather and I start reaching out and talking to other financial institutions and folks, it may be that we get some pushback on, well, why is it so much? I mean, why are people leaving with $200,000 in student loan debt? Why? And how is what they're leaving? How is that $200,000 comparable to the, you know, 75,000 I left with, and, you know, 20 years ago? So I think that's a great question. And I think that, and it's probably not a question that you know, that lots of folks want to tackle, but I think it's a legitimate question. And that is, why is law school so expensive? And are we actually pushing out, you know, are we making it impossible for there to be a diverse law school pipeline if we continue to raise the cost of a law school education?
Novella, I just had a question about the survey that you took. I don't think it's the state bar survey because we
Oh,
haven't
damn.
released it yet. We actually are planning to just test it next week.
Oh, I wonder what it was then.
So I'm curious who.
Do you
who
still
filled
have
out
it?
the
Can you
survey.
share it?
I'm gonna look in my inbox.
Oh yeah, and if you could share that with me, that would be really great. But you will be getting a survey from the state bar in
Is
June.
it, can you remind me, is it going out to just nonprofit or is it going out to all public
going-
interest? I can't
Going
remember. What,
out to nonprofit and government attorneys. And
okay, so I should get one. And judges?
if I don't know if judges are included. We can check.
Just saying. What?
Well,
That,
yeah,
that makes the assumption that judges don't have student loans still.
Yeah, we pulled the list from the licensees, and so I actually don't know how judges are categorized in that.
Okay.
But I can check.
And Novella, I was going to say that we too agree that we would prefer if they didn't have to accumulate any debt at all right at the beginning, or reduce debt from the beginning instead of trying to chase the money at the end. And so part of the discussions have been around, particularly with respect to private funding, whether that's corporate or philanthropic, whatever way is better for those institutions or people to structure it. If it's better for them to give a scholarship, as an example, if you have been accepted into a program at a law school that, tracks you for public service, for instance, then that might be a way to identify students who would qualify for that, instead of it being loan forgiveness on the back end for whatever, for donation or tax purposes. Different entities, private entities, may want to structure it a certain way, and we're certainly happy to hear whatever they would suggest that would work for them. She moved on my screen. I was like, where'd she go? And then also there was a second part to and then with respect, I think we're also, to Kristen's point about pushback, and I've talked to a couple of financial institutions individually too, or people at those, just to start to get like, am I crazy? Is this something that, we could even raise to financial institutions? And I've always pitched it as like, I think this is a great way from a PR standpoint for institutions who have, been in the press with respect to discriminatory practices, to create some reparations around that. If your scholarship is awarded to people who are going to go into law school to study fair and equitable practices in this space, then that's how you tie the two together and make it make sense, in my opinion. So.
Michael has a question or a comment.
I hope I'm not repeating too much of what Novella said, but I think it's really interesting to think about it from the law school perspective. And I'm wondering whether, in addition to approaching not only financial institutions and private institutions like Coca-Cola or the NAACP to fund scholarships on the front end, we should be approaching law schools to ask the same question, sort of what Novella was talking about with Harvard's pilot program, or on the back end, in terms of after you've been in public service for 5 years, they'll pay down part of your loan or something like that. So having them involved so that scholarships are great from private organizations, but there's no incentive then for law schools to lower their tuition. If anything, they might have incentive to raise the tuition because now you have private organizations that are paying for folks. So I'd be really interested to see how we could bring in law schools into the conversation on the front end, the back end.
Mm-hmm. I think that's a really great topic for the working group to discuss and look into at their next meeting.
Yeah, agreed.
And thank you. This is so important to our students. All of the students that I mentor, they have a heart to serve the community, and the realistic payments of their almost 300, 400, which includes their books, their not only their tuition, but the apartments that they are sharing with probably 6 other individuals in a 2-bedroom. They do their best, but they have to make ends meet. So I have so many students that say, I have a heart to serve the community. I want to go into public interest, to government. but I just can't, because the amount that I get paid does not justify how much I have to pay in student loans. And kind of going along with that, there's kind of these two tracks, which is the loan forgiveness and then any ability to reduce that loan in the first place. And I know, Elizabeth, we kind of talked about this, but I have so many different organizations that reach out to me to say, can you please get students to apply for a scholarship? And sometimes it's as minimal as 500, 1,000, but sometimes it can be as substantial as 5,000. And what I hear from a lot of the smaller known organizations, they will say, we've had 3 applicants for 4 scholarships. And we just have this money sitting around and we don't know how to get it to the students because we simply don't have enough that apply. And so I know we discussed this before, where we can have maybe partner with CLA to have a portal where it would be a link to all the different bar organizations. And it's up to the bar organizations to post their scholarship opportunities, internships, jobs, but at least let the students know. And even potential graduates, anyone that wants to transition, these are the resources that are out there. And I think it's all about information sharing, because we should never be in a situation where organizations who have the money are begging us for applicants when we know that students are struggling. And that $1,000 may be the $1,000 that helps them. So I think if we can continue to work with CLA to have that portal.
Yes, they already have a really comprehensive listing of all of the affinity bar associations on their website. And I know they also have a law school section or corner or web pages on their website. So I will, again, continue to talk to them about building that out. And they may have already, because this is a topic that I did raise with them after our last co-op meeting. So we'll continue to talk with them about that for sure.
Great. And I think the goal was to have something on the state bar website that would connect them to CLA, that would then have the list, right?
Yep. And then Sarah has a comment or question?
Yeah, I was just going to mention the Leadership Council on Legal Diversity, or LCLD, has a page that lists all the scholarships available. And, in addition to affinity bar organizations and the like, for example, my firm has scholarships to 3 1Ls. Many other firms have that kind of program that are targeted at kind of first-generation law students and members of underrepresented communities. So I'm going to put in the chat a link to their website with all of those other kind of private resources as well.
Great. Any other comments or questions?
So the survey I filled out was the ABA Young Lawyers Division's student loan survey.
Okay.
And I forwarded it to Elizabeth in case you guys
Great.
want to say.
Yeah, no, and I think we'll try to get in touch with the ABA folks and talk with them about their data and maybe share our data when we have ours. Thank you.
So moving on to the update on the early pipeline to the profession, we have Elizabeth.
Yeah, so in our work plan, we have to work on a video, kind of a follow-up video to the video that was filmed with the Golden State Warriors. And so I think, Heather, you had mentioned in the past that Disney was on board to do this. Is that still the case? I see a thumbs up.
Absolutely.
Okay. So,
we've been waiting with bated breath.
Yes. So now that our work plan has been approved for this year, we can move forward with it. And so I'm happy to work with you directly. And if there's any other co-op members who also want to participate in kind of developing that, please let me know, and then we will move forward with that video. That's going to be very exciting.
And Elizabeth, did you want volunteers now for the working group?
If I know Heather's on board, but if there's anybody else who wants to volunteer now, great. If not, I will tap people on the shoulders. Okay, I see Ryan.
I was gonna say, Ryan, you have to come back and do this with me.
Oh, and I see Sarah too. Okay, so
monopolize all the cool stuff.
I didn't want to call you out on the spot, but
okay, so I see Sarah, Ryan, and Heather. Is that?
I think Judge Kristen had her hand up as well.
Okay.
Great. And update on Judicial Council requests for assistance on judicial diversity. I don't have any current updates. However, I did want to have a discussion with Judge Yu. We have a new appointment secretary, fairly new. It's been several months. Secretary Luis Cespedes, and we were able to meet Secretary Cespedes as part of the California Judges Association. And just to give new folks on COAF some background, we used to conduct the So You Want to Be Judge seminars. We had a very close working relationship with, at that time, Josh Groban, who was the appointment secretary to Governor Brown. We would hold workshops. We would invite the Jenny Commissioner, the local bar chair, who also vets judges, and we would have routinely different seminars on how to get your application completed, insights from the appointment secretary as to what the governor is looking for, and we would travel all throughout the state to conduct these seminars. The Judicial Council has taken on that role since the change. However, I think that it's critical that we have a relationship with Secretary Cespedes. And so one of the things that I wanted to discuss with Judge Yu going forward was for the COAF members. We used to have a judicial committee for COAF members, especially the chair and the vice chair and whoever will be incoming, to have at least a conversation with the secretary, appointment secretary, and to have a relationship. And to the extent that we provide any assistance to Judicial Council, I think it's also important that we have this relationship between COAF and the appointment secretary. So that's something that I think will be in the work plan, and I will discuss further with Judge Yu. But at some point, Elizabeth, and I don't think we need to add this onto an action plan since it's part of the judicial diversity, but for us to set up a phone call with the chair, the vice chair, and any other individuals who are interested in introducing ourselves to the appointment secretary. And we will do an email to see if anybody's interested in that working group. But Elizabeth, that's something that we can incorporate as part of our judicial diversity work plan, right?
Just to have a conversation with the appointment secretary?
Right, and just to introduce ourselves and to discuss our concerns on diversity on the bench. So just to have a conversation and an intro to COAF and whoever is interested in being in that working group.
Donna, are you available?
I am. Yeah, I don't think you don't need an amendment to the work plan to do that. That's certainly something that within the supporting the Judicial Council efforts, I think fits entirely perfectly in there.
And of course, Judge Yu will be part of the working group and the committee call.
Great. And Ryan has a question?
Yeah, just to add a little more flavor to the sauce. By the way, I stand behind that 100%, fully support that. I know Luis Cespedes through other organizations, just not within the context of COAF. So I serve as the chair of the Judicial Evaluations Committee for the Wiley Emanuel Bar Association, and I serve on the Judicial Evaluations Committee for the California Association of Black Lawyers, which has a very robust evaluation process. And so getting to know Mr. Cespedes through COAF, I think would be a good thing to do as well. Thanks.
Any questions, comments? And so once I can get the details worked out with Judge Yu, we will send an email as to which of the COAF members want to be part of that working group. And we call it a working group, but it's really going to be a meet and greet with Secretary Cespedes. And going on to discussion on additional diversity and inclusion initiatives. Elizabeth?
Yes, so at our last meeting, and actually in the course of the discussion regarding the DEI leadership seal, I think it was brought up that the ABA, I think Pat brought up that the ABA is working on a diversity, equity, and inclusion resolution. So I've been in touch with their staff and the committee working on that. And so I just wanted to share with you the language that they're they will be proposing to the House of Delegates in August. It is a work in progress. In fact, I just got an email this morning that there was already some tweaks to the language, but they, in talking to that committee, I shared out what the State Bar and COAF have been doing in the DEI space, and they were very excited about a lot of the progress we've made and the work that we're doing. And so, they will continue to share their updates on this resolution. And it may be something that COAF may want to recommend that the state to the Board of Trustees that the State Bar do at some point in the future once it passes through the House of Delegates in the ABA. So let me share my screen with that language, just so that you can take a look at that. And I have, oh, here it is. Sorry, I have too many windows open. Okay. So this is the language that they're planning to present. They also have a report with support this language. But what I think what is most interesting is the hours requirement for diversity, equity, and inclusion work for attorneys. So I think we can continue to track what's happening with this resolution. And I think the working group working on the leadership seal, I think it might fold nicely into that work. And Sarah has a comment.
Yeah, I was just wondering how the ABA minimal hours for DEI compares to their recommendation of minimum hours on pro bono, just as a point of comparison.
For pro bono, it's 50 hours.
And these were some of the discussions that we had at the last COAF meeting as well. And we wanted to kind of mimic what the ABA was recommending in terms of the hours dedicated to diversity, equity, and inclusion. And so now we see that while it was a work in progress at the last COAF meeting, we see that this is probably going to be an adopted resolution by the ABA.
And it may change between now and then. They've already sent me 3 drafts in the time that we last met in February. So it is a living document at this point. But yes, it does look like they are going to move forward with recommending the 20 hours.
And thank you to our liaison, Pat Lee, who first gave me notice of the ABA proposed rules. I believe back in, was it fall of last year, Pat?
Right.
So thank you, and we've been tracking it since, so this is great.
And just to let you know, can you hear me?
Yes.
Oh, okay. And just to let you know that a lot of the changes in the future, if there are any, will go to the report that accompanies this. And a lot of it is to assure the members that this is aspirational and not mandatory, because there's some initial feedback that it's an issue of free speech and so forth. So we were trying to avoid all of those kinds of negative feedbacks. So it tracks the pro bono policy. But note that the ABA, there's actually a model rule on the aspirational pro bono policy. But that for this DEI policy, we decided to start slow, so that it's a policy at this point in time. And as we move forward in future years, if there's a lot of support for this and activity by members of the ABA, that eventually we hope to introduce it as a model rule of some sort. But we also recognize there are a lot of attorneys, a lot of law firms, a lot of organizations that are already doing DEI work, and it's all voluntary, so that attorneys who are involved in this should not have any problem meeting this minimal 20 hours per year. And maybe in the future it'll increase to track the 50 hours of pro bono aspirational activity.
Any questions or comments? Moving on to our liaison report. Do we have Ken Wayne from CLA?
I don't see him.
And let's move on to Cal Law. We have Pat Lee.
Okay, thank you. There are a number of things I wanted to bring you up to speed on. One of the main things that we're working on is SB 770 in the state legislature seeking additional funding for the Pathway to Law School programs. And thanks to the State Bar for your support on this legislation as well. That will really help as we move forward. There was a presentation to the Finance Committee on this bill. Seeking, at this point, it's listed as a $10 million bill. We don't think it'll survive that level, but hopefully it'll be enough to do the kind of work that we want to do. And it's to expand the research capacity and building of a database for the Cal Law Pathways to support program expansion of the law pathways, not only in our high school law academies and community college arenas, but also to expand into the Cal State system. We have the UC system totally involved and invested in supporting the pathways, but we also want to expand into the Cal State area so that we can then inform those students about opportunities to join in the Pathways program as well. And as I said, the Finance Committee unanimously approved that. So we're looking forward to that bill working its way through the legislature. We had our Law Day program on April the 30th, and it turned out to be a very successful program with a lot of positive feedback. We had keynotes from California Supreme Court Justice Cuellar and his wife, Federal Judge Lucy Kuo. They came on as a dynamic duo, and they were really good. They talked about their pathway to the law, to becoming judges and justices, and also on their perspectives of the rule of law. And that was very well received. And we think we're going to invite Justice Cuellar back as a participant in our upcoming Pathway to Law Program Summit in next February. We had also a review of a bar exam question because we had requests from the high school teachers and community college faculty that students at this point in time, even though they're not even in a four-year university or in law school, they're really interested in what it takes to pass the bar exam. So we had a professor, two professors go over the a criminal law and procedure question from a prior bar exam. They walked through it, looked at the issues, told the students how they should respond to that, which should go into an ideal bar exam answer. And also we focused on the non-cognitive issues that impact the successful performance of students, not only on exams, but also in their law school and earlier educational participation. And that covered things like growth mindset, resilience, imposter syndrome, lack of belonging, stereotype threat, and so forth. Because we wanted the students to know not only is it a substantive issue, but there are other issues, psychological issues that they need to be aware of that they may not even know exist or impacting their performance, so that they can be aware of them, address them prior to having to take the bar exam and performing in law school. We had two breakout sessions on whether Zoom backgrounds are freedom of speech. And Mark LaForestier, the general counsel at the California Community Colleges, was the facilitator for that. And on the second breakout, we had whether vaccines, COVID vaccines can be mandated. And we had a Pepperdine Law School professor, Barry McDonald, facilitate that session. Because it was so successful, it was the first time we did a Law Day program. Because we got such positive feedback, we're going to do another one next year. So we may be asking some of you to participate in that for us. We're continuing with our high school gatherings. The next one is scheduled for June the 22nd. And what we're going to do is take an approach where each time we have one of these gatherings, we're going to present an in-depth presentation on one of the areas of practice. So this time we're going to be focusing on immigration law, and we're going to be screening a film called Status Pending. And some of you may have seen this. It's been screening in Southern California. Amaba had a screening on this. It depicts a day in the life of 5 immigration practitioners and talks about the difficulties they have in overcoming the oppressive immigration policies, the stress that it takes to practice immigration law, and then to have a dialogue with a couple of those attorneys with the high school faculty, teams, and volunteers that will be participating in that gathering. And then we'll also be looking at ways that the teachers of the other core classes, English, math, social studies, science, and so forth, can incorporate law issues into their classes so that we have an integrated law approach in all of our law academy classes and not just in the one law class that they take every day. And that's going to be take a lot of creativity on the part of our legal staff, on the part of our law volunteers, and working with the teachers so that we can expand that curriculum and so the students will understand how not only does the law impact their understanding of the justice system, but it impacts their daily lives in a lot of things that they do. Thanks to Judge Esther, we had an initial meeting with a couple of representatives from the California Judges Association, Judge Julia Elogiamento and Judge Dorothy McLaughlin, to expand ways that the CJA can work with California law in expanding the law work to support our students going through the pathway. And we look forward to our ongoing work with CJA. Our Know Your Rights program, we actually had our first program with the De Anza High School and Richmond High School Law Academies. And this is designed for high school students in the law academies to give them information on how they should respond, what they can and should not do when encountering law enforcement in various aspects of their lives. And that was very well received as well. We had volunteers from the district attorney's office and from the public defender's office, as well as law enforcement to help make that presentation. It went very well. So we're going to expand that program into all the high schools in Contra Costa County, and then also work with California Lawyers Association and their Speakers Bureau to expand the presentation in all of the high schools throughout the state of California. Again, some of you who are involved in those law academies will be hearing about the recruitment efforts and presentation of this program in the law schools, in the high schools, sorry. We're starting to plan for our 2022 Pathway to Law Summit. We're trying to get as much of an advanced start as possible. We'll be looking at overcoming invisible barriers to success, which is expanding on the non-cognitive barriers that affect students in their success in school as well as on various exams. Empowerment through law, which will be inviting lawyers, pathway representatives who are prominent in various law practice fields to tell the students what they as lawyers can do to effectuate change and to hopefully give them ideas on what they can look at in terms of possible career pathway, law practice areas and career objectives. And then also looking at how to help support students along the pathway so that they can successfully transition from high school to community college to the 4-year and to the law school. And as Elizabeth explained, we're also kind of partnering with the ABA on that aspirational diversity, equity, and inclusion resolution. What we did from our perspective was to, in the report, list all the possible types of activities that we could think of that could be considered DEI activities, so that attorneys involved in this area would know that what they were doing already would qualify for that, meeting that aspiration, but also to give other attorneys ideas as to what they could possibly do, because they probably have a very narrow view of what DEI activities are. But there are a lot of things that can be done, like working with the law academies, mentoring students, being classroom speakers and so forth, that they may not have thought of that could be considered DEI activity. So we're monitoring that as well. And we think we're very have a positive attitude that this will become an ABA policy. It will pass the House of Delegates at the annual meeting in August, so we can then move forward from there. So that's it. Thank you.
Thank you. And as an update, after our meeting with Ruthie and with Pat and the two judges on our outreach committee at the California Judges Association, they were so excited to work with Pathways, and they also decided to implement an email. It's a outreach at CJA, and once I actually get the email, I will forward it to every member of COAF. But it will be an outreach email where we have judges statewide that are part of the outreach committee, but it will be a set email with the California Judges Association, and you could simply email that person, the outreach coordinator, and if anyone would like to have visits or have judges in the classrooms for students, law students, elementary school students, anywhere in the pipeline, then that would be the email to use. And so CJA is very excited not only to work with Pathways, but this kind of opened up an avenue for us to consider doing greater outreach simply through use of having an email. So once I have that email address, I will forward it to everyone here in COAF so that if there are opportunities for us to do outreach with students and even with young lawyers, we're happy to do so. Any questions for Pat? And we'll move on to our last report. Judge Yu is not available, but I believe, Elizabeth, we have a statement from a written report from Judge Yu for Judicial Council report on diversity and inclusion initiatives.
Yes, that's right. So Judge Yu apologizes for missing today's meeting. She had a full calendar and a court meeting, so she wasn't able to join us in person or via Zoom. But she did want to submit an update to COAF, and she also wanted to thank Judicial Council staff, Catherine Ungiri, for helping her prepare her update. So the diversity in the branch continues to be a priority, and the Judicial Council continues to highlight the Pathways to Judicial Diversity Toolkit. In 2021, they increased judicial mentorship efforts by beginning to provide technical assistance to local courts and bar associations that are starting judicial mentorship programs. Additionally, they are continuing to provide remote presentations on judicial diversity throughout 2021. Joint presentations on Pathways to the Bench with California Lawyers Association and local bar associations were held on February 19th and May 11th, 2021. The program in May targeted the Inland Empire and included opening remarks from presiding judges of Riverside and San Bernardino counties. Over 300 people attended the statewide program in February, and approximately 75 attended in May. And they have a targeted program for the Central Valley Plan for July. Planning also continues for the Judicial Diversity Summit in September. The Judicial Council is working with California Lawyers Association and California Judges Association to plan the virtual summit. Leading up to the summit, they will be hosting a series of events in August and September. On August 4th at 5 p.m., Judge Yu would like to invite COAF to a kickoff fireside chat, Judicial Diversity Yesterday, that's the title, which will reflect on the progress made over the past 15 years. Additionally, weekly education sessions planned by affinity associations will address different facets of the pathway to the bench. Those sessions will be held on August 11th, 18th, 25th, September 1st, and 8th. The summit will be held virtually and will feature opening remarks from the Chief Justice. The dates of the summit are September 14th, 21st, and 28th. There is a webpage on the California Lawyers site with additional information that I can share out with COAF. Additionally, the Judicial Council continues to work with the State Bar's Judicial Nominations Evaluation Commission, Jenny, to provide training on judicial diversity, bias, and effects on decision-making. So that is Judge Yu's report.
Thank you. And once those dates get a little closer, either myself or Elizabeth, we will send out reminders.
Michael has a question.
I know she's not here, so I can't ask it of her directly, but I wonder whether Judge Esther or you, Elizabeth, can convey. I don't know if this is a space that COAF can make a suggestion about, but I know one of the questions that I've asked before is whether when Judicial Council is collecting data on judges, whether there's a way that they can relate that data from an intersectional perspective. So Elizabeth has heard me talk a lot about this, and I know that that's one of the things that the annual report card this year will be able to do. We'll be able to see how many Latinx attorneys or female attorneys there are in, and be able to sort through the data. We can't do that right now with judges, and I don't know if there's a way that we can suggest that. I'm sure we're not the first people to suggest it, but to indicate that that's something that would help COAF in our goals as well.
So that's something that I can pass along to Judge Yu, unless Judge Esther, you know the answer to that.
Well, I know what we have so far is the governor's report that comes out every year. And I don't know, Elizabeth, were we able to share that with COAF members, the most recent report? I do have that and I can share that if we haven't already.
We haven't yet, so if you want to send that to me, I can share out. I think there's quite a few items to share out after today's meeting.
So I'll make a note of that. So the governor releases his report on his recent appointments, and it details what sector they're from, details their race, their age. There are several different factors, and I haven't seen I haven't looked at the report that much in detail. However, it does have his latest appointments. And so I think that's a start. Was there something more specific, Michael, that you were looking at?
So I think that the 3 reports that I'm aware of are that Jenny releases their own evaluation report that includes the folks that have gone through Jenny and been found qualified, not qualified, and breaks them down. But it has a fairly superficial demographic breakdown. It doesn't get as granular as some other reports as we might hope. And then there's the governor's report that you indicated, the annual governor's report, and then the annual Judicial Council report that goes through Supreme Court, courts of appeal, and superior courts. And as far as I know, only breaks it down by gender, race, ethnicity, disability, veteran status, but doesn't, and LGBTQ identity, but doesn't have any intersecting identities.
I will inquire as to Judge Yu, and we'll pass it along. And perhaps she can give an update on that at the next meeting.
Thank you.
Any other matters to discuss or any further questions? Any general discussions or questions before I ask for adjournment? And seeing none. Oh, yes, Sarah.
More kind of a general kind of question, since I'm still relatively new to COAF as of September. I mean, I think as we all know, there's been a lot of violence against the AAPI communities, you know, nationally, also here in California and here in the Bay Area. And I know that most of COAF's work, you know, has kind of a long timeline, right? And I wondered if there was the ability to do something more quickly, for example, in response to some of these national and also statewide trends, because, you know, I feel that lawyers have a special responsibility to speak up on injustice and in particular, you know, racism, right? And so it was sort of just a general question. I don't know if COAF did anything last year, for example, in connection with the George Floyd killing and brutal murder. The 1-year anniversary is coming up. So I didn't know if we had the ability to do something quickly in response to these kinds of, you know, national outrages or not. So I just wanted to kind of pose the question because I know I've been doing a lot of thinking and have been on a lot of programming about AAPI violence and awareness and bystander training and all kinds of things over the past few months. And I just wondered.
So the state bar has put out statements both after the George Floyd murder and in response to the increase in violence against the AAPI community. And so I think the state bar's statement is COAF's statement. COAF wouldn't make a statement on its own necessarily. So that has happened. I don't know if there are additional activities that you think we might want to think about.
Yeah, I would think programming of some sort. You know, not just a public statement, but a panel or a program or something else that we could partner with other, you know, groups within the state bar to put on, just to be a little more real time, you know, rather than planning something for 6 months from now or 12 months from now. Anyway, it was just a question. Maybe this isn't the right group to spearhead something like that, but I just wondered what we did last year. You know, if anything, beyond kind of the state bar statement about George Floyd. And that might inform how we might react to things in the future.
And Sarah, a lot of things have changed since the work plan has been put into place. And so we would have to see where that can fit into our work plan. And so before, a few years ago, before the new work plan was put into place, we did a lot of outreach. We would discuss certain types of activities that COAF would like to be involved in. And the perfect example would be the how do you, so you want to be a judge panel. So that would be something that someone would suggest, and we would put that together. We would be up in the forefront of providing some of those panels, discussions. But now that we have a work plan, we would have to see where we can fit that into the work plan. And that is certainly a discussion that I think we can have. And to be both inclusive in time as to what the needs are now, but also looking forward, maybe we can have a general plan of providing, and I don't know, Elizabeth, where it would really fit into the work plan, but we can partner perhaps with different bar organizations, because we don't do a lot of programming ourselves in terms of panels and all of that. And a lot of that has to do with resources, not only with fitting it into the work plan and getting approval and having that work plan be passed, which is generally why a lot of our programs are far out in advance. Because if we deviate from the work plan, or if we want to add something new, and the seal is probably one of the best examples, we have to have that to the board, present that to the board, and then we would have to take a vote on it to add that into our work plan, et cetera, which takes time. But I think maybe Elizabeth and Donna, you can give us some insight on this. If we partner with an already existing panel or an organization, I think that may be something that we may be able to do in a shorter period of time. Would you agree, Elizabeth and Donna?
Yeah, and just to give a little further context to Judge Kim's comments, we also had in effective 2018 an incredible transformation in the state bar, where the state bar sort of stepped away from its trade associational role and became a regulatory agency. And so now that we've got the California Lawyers Association assuming that sort of membership role, trade associational role, heavily education oriented role, we do look at things through that lens of, is this appropriate for us as a regulatory entity, or maybe more appropriate for the California Lawyers Association, where we could provide them input, suggestions, participate with them in some ways. And so this is one of those things where, you know, I think we might want to look to that avenue. And it's one of the reasons certainly that we've got a liaison with them, is to talk about sort of opportunities that they may be looking at and ways that we could assist them in doing that. I think that might be sort of the most expeditious way to accomplish something like you're talking about, Sarah.
And Sarah, maybe what we can do is connect you to Ken Wing, who is our CLA liaison. And we could do an email intro. Elizabeth, maybe we can do an email intro between Ken and Sarah and anyone else who is interested in COAF, so that we can look into opportunities. Because I think I completely agree, we want to be at the forefront. But having said that, there are protocols and there are working plans, and there's the board of trustees that we kind of need to balance where our resources are going to be used. And I'm sure when Elizabeth shared our report to legislature, we do a lot, and our staff, I'm shocked at how anybody gets any sleep with all the work that they do. So I think the best way is to connect you with Ken, and we can look at partnership opportunities. And we could do that, Elizabeth, and maybe have some sort of a report at the next COAF meeting. Anyone else interested in being part of the email chain with CLA to look at opportunities? Kristen? Brian? And so maybe we can do an email intro with everyone, with Ken.
Great.
That's great. Thank you very much, Judge Kim.
Thank you. Novella, did I see a hand? She looks so calm behind that.
I know.
Waves. And without further ado, can I get a motion to adjourn?
I'll move to adjourn.
Thank you, Michael. A second?
I'll second.
Thank you, everyone. And the meeting is concluded at 1:36, and we will see you in a few months. Thank you, everyone.
Thank you.
Thank you.